Magandang umaga po, everyone. To Justice Kim Posale, to the uh, professors who are around, and to those who are live on stream, and to our guests from Japan with I got their cards so I can recall their names. Mr. Yabuki-san and Mr. Moto-san and Mr. Dan-san. The Integrated Bar of the Philippines, being the official organization of lawyers in the Philippines, is glad to participate in an activity like this one. Marriage dissolution and inheritance, although the theme is something that Filipinos who are married to Japanese would not really like to undergo, dissolution of marriage. But with 240,000 Filipinos in Japan, I would say it is inevitable that something like this would happen. Even just 1% of 240,000, that would mean 2,400 cases of dissolution of marriage or inheritance in case the spouse have already passed on. And I hope that an activity like this, under the auspices of the University of the Philippines, will help both countries, particularly Japanese who are married to Filipinos and also Filipinos who are married to Japanese nationals, have a common understanding on the procedure and the law that will benefit both sides. I would like to share a little secret with you, personal secret. 50 years ago, when I was still in college in Tacloban, I met a Japanese girl. I still remember her address in Tokyo. Setagayaku, Omegaoka, Tokyo, Japan. Well, I would say that we fell in love. Maybe that was my first love in my life. I was 18 years old at the time. Who knows, had that relationship blossomed, but I am sure we would not undergo dissolution because we were madly in love with each other. My law partner is laughing. Attorney Bingbing Fernando, we were partners before in the same law firm. But as I said, some things are inevitable. And I hope that with an activity like this, both sides of the relationship, meaning the Japanese and the Filipino, will be able to benefit from a sharing of ideas and hopefully to harmonize our laws. For the information of our friends from Japan, our Philippine Congress, as I have said, had just passed a bill on divorce. And the possibility of that law being passed under this administration is quite high. So, if the Philippines will have a divorce law for the first time since 1935, then hopefully that kind of law will be harmonized with the laws of Japan that will benefit both sides of the relationship. And with that, I would like to welcome everyone, particularly the chairman of the Japan Bar Association, also who I think is online, Mr. Kobayashi-san. And I would like to say thank you very much and congratulations to Professor Raj Palacios for bringing in the Integrated Bar of the Philippines for this kind of activity. And we hope for a successful conference on this matter. Thank you very much.
We will now hear a message from the President of the Japan Federation of Bar Associations, Attorney Motoji Kobayashi.
Good morning, everyone. It is with regret that I am unable to meet you in person today in the Philippines, but I would like to say a few words. This conference is co-hosted by the Integrated Bar of the Philippines, also known as IBP, the University of the Philippines Law Center, and the Japan Federation of Bar Association, in short JFBA. On behalf of JFBA, I sincerely welcome and appreciate your participation. Since the IBP and the JFBA co-hosted the Philippines-Japan Law Conference in Philippines in November 2017, we have deepened our relationship by alternately holding joint seminars in the Philippines and Japan, focusing on family law issues. And we signed the friendship agreement on February 14th, 2020. This will be the first time since the Philippines-Japan Law Conference 2021 on comparison of Philippine-Japanese family law and nationality law was held online in 2021. Today, the JFBA is sending a delegation to hold the conference in person in the Philippines, while having it available online. Such a conference in person could not have been held since the seminar at the time of signing of the friendship agreement, which was indeed 3.5 years ago. However, we are sincerely pleased to be able to hold such a joint conference again. In addition, the University of the Philippines and the JFBA signed Memorandum of Agreement on January 13, 2023, pursuant to which Attorney Takayuki Obata has been dispatched to the university as visiting researcher. We would like to express our sincere gratitude to the University of the Philippines for accepting him, and hope that this conference will lead to future development of cooperative relation with the University of the Philippines. Regarding the family law in the Philippines and Japan, the morning session will focus on dissolution of marriage, with particular emphasis on Japanese divorce system and procedure, and recognition of foreign divorce in the Philippines. In the afternoon, we will take up inheritance as the topic of the first time, and we'll have respective experts from the Philippines and Japan speak about the system in their respective countries. We are confident and hope that by learning about the system of both countries and their differences, all participants will be able to deepen their knowledge and make use of it in their respective expertise and practice. With those words, I would like to conclude my opening remarks. Thank you very much for joining us today. Salamat! Salamat!
Thank you very much, Attorney Kobayashi, the President of the Japan Federation of Bar Associations, the co-organizer of this conference. Thank you also to the National President of the Integrated Bar of the Philippines, Attorney Antonio Pido, the main organizer of this conference and the host. The conference has been going on since 2017 and is really based on the strong friendship between the IBP and JFBA. However, it would not be successful without the support of other groups. For this conference, we have the support of the Philippine Bar Association, the oldest voluntary lawyers group in the Philippines, here represented by its president, Attorney Ernestine Jo Villarreal Fernando. Another event partner is the Philippine Society of International Law, represented by its president, Professor Elizabeth Aguiling Pangalangan. Later on, we will mention the other event partners for this conference. We now move to part one of the conference. I would like to invite on stage our moderators for part one, Attorney Jamie Reyes, a lecturer in the Ateneo Law School and a political officer of the Embassy of the Kingdom of the Netherlands in Manila, and Attorney Masao Dan, regional partner of TMI Associates based here in the Philippines.
Good morning, everyone. For today's first panel, we have a very interesting topic, as already mentioned by our previous speakers. Divorce in its recognition in the Philippine jurisdiction. As most of you already heard, the Philippines is only one of 2 countries in the world that doesn't have divorce, where divorce is illegal. The other one is Vatican City. However, judicial processes have allowed for the recognition of divorce decrees obtained from foreign jurisdictions. And today, we'll hear about, we'll hear particularly from the perspective of Japanese law. To introduce our first speaker, I invite Masao-san.
Magandang umaga po, everyone. This is Masao Dan. So let me introduce the first speaker of today's conference. He was admitted to the bar in Japan in 2009, and in 2013 he went to London and studied international human rights law there. During his stay in London, he was also engaged in activities by a Japanese NGO supporting refugees from Serbia and Kosovo. After his time in London, in 2014, he came to the Philippines and took his internship at the Commission of Human Rights in Tacloban, Leyte. He went back to Japan, sadly, in 2015, and since then, he's been practicing family law, which includes the Hague Convention cases for child abduction and visitation, and labor law issues and immigration cases. It is also notable that the majority of his clients are foreign nationals. To date, he has been reaching out to people who are in need of legal support and representation, both in Japanese and English language. Everyone, please welcome our speaker on Japanese on divorce, Attorney Seiji Yamamura.
Thank you, Attorney Dan, to introduce me to the audience. Magandang umaga po. I'm Seiji Yamamura. Then today I'm going to talk about the Japanese family law on marriage and divorce, like dissolution of marriage. To understand the dissolution of marriage, I think it's better to explain about the marriage as well. So that's why including marriage. Then presentation today is like Japanese family law on marriage and then Japanese family on divorce. Then this is a list of presentation today. applicable law for marriage and then marriage between Filipino and Japanese will be explained first. Then after that, applicable law for divorce and divorce by agreement and judicial divorce will be explained. But the divorce by agreement will be on the presentation for Attorney Obata, so I will skip this part. Sorry, the presentation is not, a slide is a slide broken, but it's a marriage between Filipino and Japanese, then applicable and then procedure for marriage will be, I'm going to explain. In Japan, applicable law for marriage shall be like family law and then Family Register Act law and then conflict law. Then first of all, family law is prescribed in Part 4 of Civil Code. Then the conditions of marriage as well as procedure of submission of marriage report are stated in family law. Then Family Register Act is called Koseki-ho in Japanese. It's stipulated procedure of submission of marriage report. Then lastly, conflict of law is relating to the governing law, whether or not Philippine or Japanese law applied for the case. Then first of all, I'm going to explain about the family law. There are several conditions for marriage in Article 731 to 741. For example, marriageable age, which is 18 years old above, prohibition of bigamy, and the period of provision of remarriage. The procedure is stated in Article 739. Submission of marriage report to a local municipal office, and also 2 adult witnesses are required. Then, in Family Register Act, there are several procedures are prescribed. First of all, surname should be decided. Then, but this one is not applied for foreign nationals because they don't have family registration in Japan. Then next is submission to the local municipal office where a couple lives, or honsekichi, or other municipal office with a submission of family registration called hoseki tohon. Then other conditions are prescribed in Ordinance for Enforcement of the Family Register Act, actually Article 56. And this is the image of marriage report. And on the top of the side, left side is marriage report, then submission to the mayor of the local municipal office. Then left part of the left side is husband part, the other side is wife side. And date of birth, address, and family registration address, or choose family name. Then below of the left part is signature of 2 parties, like husband and wife. Then right part is witnesses. Then this size is an A3 size document, which can be downloaded in any municipal office. And move on to conflict law. Conflict law is called Act on General Rules for Application of Laws. Then in this act, Article 24 is governing law, which is whether or not Japanese law or Philippine law will be applied. Then Article 24(1) says the formation of marriage is governed by the national law of each party. So, but the formalities for marriage are governed by the law of the place where the marriage is celebrated, which is Article 24.2. However, Japanese law shall be applied if a marriage is celebrated in Japan and either party to the marriage is a Japanese national, Article 24.3. If this article is applied, the couples, like Japanese husband and then Filipino wife married in the Philippines, Article 24.2 will be applied. Then the procedure of marriage in the Philippines should be followed, Family Code of the Philippines. Then the marriage in the Philippines shall be registered in Japan. On the other hand, if the couples married in Japan, Article 24.2 and 24.3, mainly 24.3 is applied, so the procedure of marriage in Japan should be followed, such as Japanese Civil Code, Family Register Act, which I explained already. Oh, sorry. I skipped this part. This is what I explained. Then this is a procedure issue. If married in Japan, submission of marriage report, Koseki Tohon, to a local municipal office in Japan, then additional document is certificate of no marriage record, SENOMA, from PSA for Filipino spouse is required. On the other hand, if married in the Philippines, after the marriage in the Philippines is registered, submission of the marriage report to the local municipal office is accepted. In this situation, marriage certificate from PSA is required. Now I move on to like divorce issue. Then, first of all, applicable law for divorce in Japan is part 4 of Civil Code, Family Law. Then Family Register Act, also conflict of law. They are same as marriage issue. Then in family law, divorce by agreement as well as judicial report, divorce are prescribed. Then divorce by agreement, which will be explained later on by Attorney Obata. So, but Article 763 says a husband and a wife may divorce by agreement. It's prescribed. Then this issue will be also explained later. So, this is a divorce report, but it's also explained later. So I will skip this part. Then this is a request for the acceptance of divorce notification. Like a divorce report may sometimes be submitted by Japanese husband without the consent of Filipino wife. Then in order to avoid that situation, this procedure is prescribed in law. So if Filipino spouse submit this report, notification to the local municipal office, then the municipal office will not accept the divorce report from the husband. So this is, people don't know these things, so I think this procedure should be like informed to the foreign nationals in Japan. Then from here, I'm talking about like a general topic of the divorce. Then there are 5 types of divorce in Japan. First one is agreement, 協議離婚. Then others are mediation, called 調停離婚. Then adjudication, 審判離婚. Judicial settlement, 和解離婚. Judgment, 判決離婚. There are only 5 types of divorce in Japan. Then judicial divorce is prescribed in Article 770 in family law. Then there are 5 grounds for divorce. Like one is a spouse has committed an unchastity, abandoned by a spouse in bad faith. It is not clear whether a spouse is dead or alive. If a spouse is suffering from severe mental illness. Then last one is any other grave cause making it difficult to continue the marriage. Then basically in Japan, the 5 last one, grave cause making it difficult to continue the marriage, is a ground for divorce. So the lawyers should prove this ground in Japan. And this statistics is kind of old, 2009, but basically around 10% is still divorce in the court in Japan. But this one should be also explained later on by Attorney Obata. Then now I'm going to talk about the procedure for mediation and adjudication at the court. 調停離婚or 審判離婚. Then application form is provided on the website of Tokyo Family Court. Then application form should be filled up in Japanese. It's Court Act 74. The court fee is around 3,000 yen, around like 1,200 peso at the moment, including postal stamp. Then application form should be submitted to the court that has jurisdiction where the other party lives. The court where the other party resides has jurisdiction, according to Japanese family law procedure. This is I inserted the application form for mediation and then adjudication, but it's not shown here. So this is a sample of application form for mediation. Then the top is Tokyo Family Court. Then applicant's hanko or signature is necessary. Then applicant, respondent, children. These information should be filled up on the application form. Then this is another page of the application form. Then actually mediation can be dissolution for marriage. We can apply for reconciliation as well. But the right one is a divorce. Then in divorce mediation, these issues can be discussed. Divorce, parental authority, visitation, child support, division of property, compensation for mental damage, and split of pension. Then below one is reason for application. Then date of starting cohabitation and separation date should be mentioned here. The motive of application should be only circled. There are 13 reasons. Then one is incompatible affairs, violence, too much drinking, etc. So you can just circle it. Then this application is sufficient to submit to the court for mediation or divorce. And procedure for mediation, these procedure, I mean, the situation in the mediation in Japan, there are two mediators. Then if the foreign national is a applicant or respondent, interpreter is necessary, since only Japanese can be used in the mediation. But some mediators can understand English, then in that case, interpreter is not needed. Then parties will not see each other during the mediation. So it's, I think, different from other countries. But the presence of attorney is not required for mediation, because just mediation is explaining the reason why they want to get divorced. So it's not necessary. But around 70% of the cases are handled by attorney. The person who has parental authority, child support, division, property, visitation, pension split shall be discussed as I explained to you. If parties reaches to the agreement, judge will issue the settlement agreement. This is a photo of the situation where mediation is held in Japan. It's a small meeting room. Then two mediators, one is female and then another is male. Then applicant is alone here. If there's attorney, like he or she will sit beside her. Then still procedure for mediation. The paper mentioned about divorce is provided by the court in addition to the settlement agreement. Then the party shall submit the paper certifying the divorce to local city office. Then it's called chote rikon. Then the procedure will be finalized. If the mediation is not reached to the agreement, but both parties agree to get divorced and receive the decision from the court deliver adjudication called shimpan rikon. But the number of shimpan rikon is very huge in Japan, so there's no statistics in my slide. Then if the judge concludes that there's no chance to settle the case through the mediation after having several sessions, usually the mediation will be closed. Then the party can move on to litigation. According to the procedure for divorce litigation, like Domestic Relation Case Procedure Act should be followed. Then prior to filing the petition paper of divorce to the court, having mediation before litigation is required. However, if there's no possibility to have mediation, such as the other party address is unknown, even if checking Juminhyo residence registry or checking the address itself, mediation is not required, meaning that we can file a case to the court, start a litigation immediately. And this is a courtroom in Japan for not only family cases, any cases. Then judge is top of the seat. Then court officer is in front of the judge. Then left one is petitioner, then other side is respondent. Then if interpreter is needed, then she or he will sit beside the court officer. Then now move on to the topic of procedure for divorce through litigation. Then it's hanketsu rikon or wakai rikon, judgment or judicial settlement. Of course, attorney's representation is better to have it, but it's not required. Some people doesn't want to hire attorney for divorce case. There will be several court hearings held until the points of the case are clarified by the judge and both parties. Then after that, we will usually have a cross-examination for both parties. then interpreter's fee should be deposited by foreign spouse. Then, if foreign spouse win the case, interpreter's fee should be borne by other party. And duration of cross-examination is usually total 90 minutes for both parties. But if interpretation is necessary for foreign spouse, then it will be longer, like a double time. And after the cross-examination, usually the judge will offer to settle the case because they don't want to write a judgment usually. So then if both parties accept the settlement, judicial settlements for divorce, wakai rikon is reached. If both parties deny the settlement, then judge will deliver the judgment. After both parties receive the judgment will be finalized in 14 days according to Japanese law, unless there's an appeal from either party to the High Court. After judgment is finalized, either party can submit the judgment to any local city office with koseki tohon. Then it's finalized hanketsu rikon. And this is a presentation today from me. Yeah, thank you very much for listening to my presentation. Salamat.
Thank you very much, Attorney Yamamura, for the very comprehensive presentation. So our next speaker is also a practicing Japanese attorney with 14 years of career. He specialized in family law, child rights, and activities on non-profit organizations, including social entrepreneurships. From 2018 to 2019, he served as a visiting scholar for the New York University School of Law, where he conducted researches on adoption systems. After coming back to Japan, he worked for the Cabinet Office of the Japanese government for 2 years as an assistant director and engaged in policy making and activities on NPOs, among others. Currently, he is dispatched to the University of the Philippines College of Law as a visiting researcher from JFBA. Please welcome our next speaker on Japanese procedure on divorce by agreement, Attorney Takayuki Obata.
Thank you, Dan, for introducing me to your audiences. Hello, everyone. Maganda umagapo. I'm Takayuki Obata. Thank you for getting the opportunity to give a presentation about Japanese procedure on divorce by agreement. My presentation is the first sentence in this case study. Japanese male and Filipina obtain a divorce by agreement in Japan. This is overview. First, I will explain data. And second, governing laws of divorce by agreement. And the third, requisites. And fourth, effect of divorce. And lastly, a hypothetical QA, if there's time. Over the next 20 minutes, I will delve into Japanese procedure on divorce by agreement. And I hope you guys understand it. This is data on annual trends in divorce by type of divorce. Almost 90% is divorce by agreement, which has been the prevalent type of divorce in Japan. But this percentage has been a slight downward trend. The percentage was 95.5% in 1950, but it was 88.3% in 2020. And the graph is a bit different, but it's okay. This is the data on the current trends involved by court. Even a divorce involved by a court, a divorce in the mediation has been the prevalent way based on the reached agreement. So from 8 to 10% of the divorce was gotten in the mediation. What I would like to say is that agreement or settlement is very important in a divorce procedure, even involved by court. I would like to explain governing laws of divorce. First one is Civil Code, and next one is Family Register Act, which is frequently referred, and also Ordinance for Enforcement of the Family Register Act. This is the ordinance of the Ministry of Justice. This is structure of Civil Code regarding divorce, as Attorney Yamaura mentioned. Part 4, relative, is family law. And in the part 4, there are several chapters. Chapter 1 is general provisions. Chapter 2 is marriage. And in the chapter 2, there are marriage section, the marriage section and a divorce section, including divorce by agreement and a judicial divorce. Then you guys might think, can people get divorced only by agreement without a court procedure? Yes. This is Article 763. A husband and wife may divorce by agreement. So what are the requisites? Divorce by agreement is established on agreement or divorce by a couple to get divorced and notification. What is the agreement? It is said it means matching intentions. And what's the notification? I will explain that. This is the first requisite, agreement, specifically matching intentions. The ground is not divorce article, but marriage article. However, we use application of analogy of this article. In Article 742, marriage or divorce shall be void in the following cases. If one of the parties has no intention to marriage or divorce, it's void. This idea is supported by Article 24 of Constitution of Japan. Marriage shall be based on the mutual consent of both sexes. So mutual intentions are very important to get married and divorced as well. That is why, in general, it is said that the 4 acts of personal status, family relationships, such as marriage, divorce, and so forth, to be established, the intention to commit act or the personal status and the notification of the act are required. As for notification, of course, I will explain it later. And there is a Supreme Court decision holding that the notification of divorce is based on the mutual intentions of both parties to dissolve their legal marriage. So at that time, the divorce was valid. And let's move on to the next requisite, notification. When you hear of notification, you might come up with several questions about the notification. Oh, what should I do first? And what is the format? To where should I submit it? I'll explain it. The provision of Article 739 and some of marriage articles shall apply mutas mutandis to divorce by agreement. So we can use Article 739, marriage or divorce, shall take effect upon notification pursuant to the Family Register Act. So you shall conduct notification and need to refer to the Family Register Act. And what's the notification? The notification shall be given by a document with the signatures of both parties and not less than 2 adult witnesses, and or given orally. But I've never heard of people using the oral way. It's very rare. So people submit a document of notification to the mayor. Anyway, you shall find 2 adult witnesses. And a notification of the divorce may not be accepted unless the divorce has been found not to violate the provision of the previous articles, 739, 819, and any other laws and regulations. Then Article in 819, if parents divorced by agreement, they may agree upon which parent shall have parental authority in relation to a child. So you also shall decide which party will have parental authority. And after that, you have to fill out the form. The form of divorce notification is statutory and should be filled out accordingly. The form is Appendix 13. I'm going to omit the minute articles. This is form of notification of divorce. And then I'm going to split it into 3 parts to explain to you guys. This is notification of divorce. The parties write down the date of submission to the mayor and the name, date, date of birth, address, and registered domicile in the family registry. If he or she is foreign national, please write down only his or her nationality. And a type of divorce. The parties check the box of divorce by agreement and write down name of minor children, child over whom the husband or the wife has parental authority, and a signature and seal of each notifier. Seal is optional. Sorry, it's it's a bit hard to see. Previously, seal was mandated, but the policy changed. And 2 adult witnesses are required in the case of divorce by agreement. Signature of each witness and the date of birth, address, registered domicile. Why are 2 adult witnesses required? It is because a witness attests a third party that the couple is divorcing by mutual voluntary intention. This ensures the truthfulness of the divorcing party's intentions and the accuracy of the notification. So it's very important. So filing out the form has been done. What's the next? Where should the parties submit it? Notification must be submitted in a municipal mayor, especially in the locality of registered domicile or the notifying person's addresses. And if notification involves a foreign national, the place to submit it is in the locality of the notifying person's address. Because foreign nationals don't have family register in Japan, which means they don't have a registered domicile. So the couple between Japanese and foreign national will submit to the mayor in the locality of Japanese registered domicile or each address. And this is the next step, confirmation of identification. I think you guys might imagine this very easily. The mayor of a city, is to require the person who has appeared to present their driver's license and any documentation in order to confirm whether or not the person is any of one of the parties. It's a bit hard to see. After the submission, the next step is acceptance or non-acceptance is a very important part. The contents of the notification with attached document are examined to determine whether they are appropriate in accordance with the requirement of Civil Code and Family Register Act. So what is acceptance? Acceptance is an administrative disposition by the mayor of the municipality to approve or not to approve the submission. So specifically, you might say the language notification in the Civil Code includes submission and acceptance. And if it's accepted, acceptance number will be given by the mayor, like that. The duration of the procedure depends on the municipality. But I heard some municipalities can finish it around 1 hour or sometimes, like tomorrow. So it doesn't take so long. And is there national uniformity in the administrative disposition? Yes. The Minister of Justice may set standards with which the mayors of municipalities must comply. And the Director of the Legal Affairs Bureau, with the jurisdiction over the location of municipality, may request reports from or give advice or may make recommendation or give instruction to the mayor of municipality. Besides, the mayor of municipality can make a contact to the Director of Legal Affairs Bureau as well. What's the next after the acceptance? The municipal mayor of the place of the registered domicile shall make an entry in the family register without delay. The procedure takes about 1 week. So when you submit a notification, you don't get any proofs of that. But in around 1 week, you can get the certificate of the family register reflecting the notification very easily. Probably, I think you might think what a family register is. So I'm gonna explain it. The family register system is designed to register and certify a person kinship status, husband and wife, parents or children, siblings, etc., including individual matters such as name, gender, birth, and death, and basic status such as marital relationship, divorce, parent-children relationship, something like that. So that is why any Japanese can use the certificate of family register as a birth certificate and death certificate, certificate of marital relationship, and divorce as well. So it's very easy to prove the divorce by using the family register. Family registers are complied only for Japanese citizens, not for foreigners. If a foreigner gets married with Japanese, the foreigner's information will be registered in the Japanese family register. So I'm going to show an image of certificate of all records in the family register. There are registered domicile, name, and person registered in the family register, date of birth, father, mother, relationship with their parents. Important part is matters of the personal status. And the birth, marriage, and divorce. And then you can see date of divorce, May 30th, 2023. It's just a hypothetical record though. Name of spouse. If spouse is not Japanese, his or her nationality. Date when the forwarded notification was received, and person who accepted the notification. In this situation, I think the parties submitted the notification in the locality of not a registered domicile, but each of address. Because municipal mayor needs to transfer the notification to a mayor in the locality of the registered domicile of them. Besides, this is note. The written word here is just date of divorce. But actually, this means a divorce by agreement. If you get divorced by any other type of divorce, for example, mediation settlement, judicial judgment, etc., those divorces shall be written in this column, such as date of settlement. Again, the word itself, date of divorce, means it is divorce by agreement. So, can you see this? How do people prove a divorce? There are 3 types of documents. First, the certificate of family register, which I've already mentioned. This is sufficient to prove it. You do not need to ask any other certificates. However, just in case, I'm gonna explain that there are the 2 other certificates. One is certificate of acceptance of divorce notification. The other is a certificate of the particulars stated in the divorce notification. The second one is states that the divorce notification itself has been accepted. The third one is usually a photocopy of the notification. As I mentioned, you might have to wait for around 1 week to get the certificate of family register reflecting the notification. So if you would like to get the proof of acceptance of divorce notification as soon as possible, you can get number 2 certificate soon after it is accepted. And this is a note that the certificate of family register number 1 and number 2 can be obtained by the notifying person at any time. But the certificate of particulars, number 3, is for a limited purpose, so to speak, special reasons. This one? Special reasons. For example, the notification was forged. So I want to make sure signature of mine, probably that might be different or something like that. So what's the certificate of acceptance of divorce notification? So this is an image. This might be translated into certificate of divorce report maybe, but specifically it is a proof of acceptance itself. This is based on Article 66 Ordinance and Appendix 20 format. This is not a form, but a format. So that is why the form is different from each municipality, but the format, the contents are the same. So you don't worry about it. The most important part is the last, this part. This is to certify the notification above was accepted on the date. So you guys can understand when the notification was accepted by the mayor. Let's move on to the last topic, effect of divorce. This is just a reminder of structure of civil code. Divorce is stipulated in section 4 of chapter 2. But you guys can use general provisions as well. What's the effect of divorce? Of course, the end of marriage. Which means effects arising from the marriage are extinguished for the future. Responsibility for cohabitation, mutual cooperation, and assistance, sharing the expense arising from the marriage will be over. And the distribution of the property, reversion to previous surname by divorce, and the capacity to remarry. When I came to the Philippines, I've been asked about what the grounds of the effect of the end of marriage and the capacity to remarry are many times. And I was surprised because it's natural for us, and there is only one meaning of divorce in Japan, so to speak, absolute divorce. But I tried to explain it. So why can divorce have an effect of the end of marriage? This might trigger some discussions, but I'm willing to go for it. For a reference, there's Article 728, Paragraph 1. The relationship between relatives by affinity shall come to an end by divorce. Technically, this is not a marital relationship directly, but a relationship between relatives by affinity by divorce. However, I can say this means divorce determines not only marital relationship, but also any affinity relationship, absolutely and automatically. Paragraph 1 of Article 728 is confirmation of the consequence of ending marital relationship, which ends any relationship established by marriage as a natural thing. So this article is premised on the end of marital relationship, absolutely. So this, how about capacity to remarry? So divorce terminates not only marital relationship, but also any relationship, absolutely and automatically, which means it is a very natural idea for us that the divorced person may remarry. But if there is any other article, I try to find it. Rather, I can say there is no article of prohibiting the divorced person from remarrying, other than one article below. Can you see? There is article of period of prohibition of remarriage in the Civil Code, Article 733. A woman may not remarry unless 100 days have passed since the day of dissolution, which includes divorce, right? And it shall not apply to cases where the woman was not pregnant at the time of the dissolution of the previous marriage or gave birth after the dissolution of the previous marriage. So why? Because this is to determine paternity and prevent disputes over paternity. It is amended in 2016 in accordance with the Supreme Court decision. The previous language was 300 days before, but the 300 days was a daily restriction to women. So that is why this article was amended in 2016. So I think you can also apply this article for the ground of the divorced person capacity to remarry. It's possible. It's possible, I think. But this is a note. This article is still inequality to women, right? And so the act for a partial revision of the civil code, etc., was enacted last year, December, and promulgated the same month, and will come into effect on April 1st next year, which will delete this article 733. At that time, you can say, oh, there is no article prohibiting the divorced person from remarrying in Japan. So I think 728 can be the ground article of capacity to remarry indirectly. It's my opinion. And I think I don't have a lot of time, so quickly, hypothetical QA. Can a foreigner spouse conduct a divorce by agreement with a Japanese spouse living in Japan? Yes. If either husband or wife is Japanese national who has habitual residence in Japan, their divorce is governed by Japanese law. And next. A spouse did not know or have intention to the divorce by agreement. What can he or she do? No intention to divorce by agreement is void. So first, you may file a petition for conciliation, a mediation first. And where there is no likelihood that any agreement to be reached, the personal status litigation may be filed. Next. And spouse consented to divorce by agreement because of fraud or duress. What can he or she do? The divorce by agreement is voidable. So first, conciliation, mediation, and second, litigation. Can I conduct the divorce by agreement orally? It's unheard of, but the couple to be divorced and at least two witnesses all must appear and make oral statements of the particulars in front of the official in charge of family registration. And the statements are read aloud to them, and the notifiers and the witnesses must sign the form. And lastly, a husband forged a wife's sign and make the mayor make a false entry in the family register. Would this be crime? Of course. This could be penal code below, counterfeiting private documents with the use of a seal or signature of another person, and the person who makes a false statement before public employees, thereby cause the employee to create a false record on this electric or magnetic record. And if the spouse remarry, that might be a possibility of bigamy. Yeah, I'd like to express my gratitude for your attention in my presentation, and we hope that divorce by agreement can be recognized in the Philippines to correct the absurd situation where only Filipina spouse cannot be divorced, even though the Japanese spouse can get divorced and remarry. So. Thank you so much.
Thank you very much, Attorney Obata, for your excellent presentation. Now, we go to our keynote speaker for this morning. Our keynote speaker has been in the judiciary for the last 21 years, and while she was a Metropolitan Trial Court judge, she received the Supreme Court's award for Most Outstanding MTC Judge. While a regional trial court judge of a family court in Quezon City, the Supreme Court also selected her as Most Outstanding RTC Judge. She was given the Most Outstanding Family Court Judge Award twice and has been cited for her exemplary performance as a magistrate with a passionate advocacy for women and children. She is currently an Associate Justice of the Court of Appeals of the Philippines. She has been a member of the Supreme Court Committee on Family Courts and Juvenile Concerns since the committee's inception in 2014. Since 2018, she has been the Philippine Judiciary Representative to the International Hague Network of Judges of Private International Law under the HCCH 1980 Child Abduction Convention, and to the Working Group of the ASEAN Chief Justices on Cross-Border Disputes Involving Children. She is also a professional lecturer of the Philippine Judicial Academy and has been a lecturer in many national and international conferences on family law and private international law. Ladies and gentlemen, our keynote speaker on Philippine law and procedure on recognition of Japanese divorce, Honorable Justice Angeline Mary Kimpo Sale. A round of applause, please.
Thank you, Attorney Jamie. I would like to greet Attorney Antonio Pido, the President of the Integrated Bar of the Philippines, Attorney Ernestine Carmen Jo Desiderio Villarreal Fernando, the President of the Philippine Bar Association, Professor Raj Palacios. I would like to greet also Professor Beth Pangalangan, sorry, and Professor Jom Lutilia, and all the others who are present, including Attorney Kobayashi, the President of the Japan Federation of Bar Association, Attorney Yabuki, the Chair of the Board of Committee International Affairs, and all the members of the Integrated Bar of the Philippines, the Philippine Bar Association, and the Japan Federation of Bar Association. Magandang umaga po, maayong buntag, and Ohayo gozaimasu. Is that correct? Thank you. My husband is always in Japan because he's with the Seafarers Labor Federation. So now I will touch on the recognition of Japanese divorce, Philippine law and procedure. And of course, as of November 15, okay, as of November 15, 2023, we don't know what's gonna happen next. Okay, so next page, please. The topic will, the outline of my presentation will cover the law, the first part. The second part will be the procedure. The third part will be the jurisprudence. The fourth part will be international conventions, Supreme Court circulars, and other matters. And the fifth part will be a summary. Okay, so let's start with the law itself. Okay, for the law, of course, it's the family code. Okay, can we, next please. What particular provision in the family code? Article 26. Article 26 states that all marriages solemnized outside the Philippines in accordance with the laws in force and in the country where they were solemnized and valid there as such shall also be valid in this country, except those prohibited under Articles 35, 1, 4, 5, and 6, 3, 6, 7, and 36, 37, and 38. The second paragraph is what we would go into, where a marriage between a Filipino citizen and a foreigner is validly celebrated, and a divorce is thereafter validly obtained abroad by the alien spouse, capacitating him or her to remarry, the Filipino spouse shall have capacity to remarry under Philippine law. Okay, and what are the elements of this second paragraph? There should be a marriage between a Filipino and a foreigner which was validly celebrated. Number two, the divorce is obtained abroad by the alien spouse. It says here alien spouse. Number three, the alien spouse is capacitated to remarry. And number four, the Filipino spouse shall likewise have the capacity to remarry. Okay, these provisions have already been interpreted by the Supreme Court, and they have been expanded. They have been extended to many circumstances based on the legislative intent, not on the words, the exact words stated in the family code, but on the intent of the legislature when they prepared that second paragraph. I will go into that later when we go into jurisprudence. Okay, so second part will be the procedure. So for the procedure, we have, okay, can we flash? From the rules of court, this is our this is our first premise. The effect of foreign judgments or final orders, the effect of a judgment or final order of a tribunal of a foreign country having jurisdiction to render the judgment or final order is as follows. Letter A, in case of a judgment or final order upon a specific thing, the judgment or final order is conclusive upon the title to the thing. And B, In case of a judgment or final order against a person, the judgment or final order is presumptive evidence of a right as between the parties and their successors in interest by a subsequent title. Third, in either case, the judgment or final order may be repelled by evidence of a want of jurisdiction, want of notice to the party, collusion, fraud, or clear mistake or of law or fact. Okay, when this rule was when this took effect, there was a question: what kind of procedure should we file in court? What rules should we follow if we want to have this this judgment abroad, rendered abroad, be recognized in the Philippines? What procedure? When I started as a family court judge in Quezon City in 2007, there were cases there that they just followed ordinary civil procedure. They file a petition, and then they present evidence. There's nobody opposing party. Then the court will render decision. But will that give power or authority to for another prayer for them to cancel, to have certain entries in the civil register be canceled? The Supreme Court said no. We have to follow Rule 108. And what is Rule 108? It is a special proceeding. A special proceeding is a remedy to establish a right, a status, or a particular fact, and that should be followed. And you know, it kind of changed everything, because in ordinary civil action, just serve summons to the respondent if there's one. But in Rule 108, there should be publication. There should be publication there. So the procedure, if the intention, the prayer is to cancel the fact of marriage there and enter a new one about the fact that the marriage has already been dissolved, there's already a divorce, then we should follow Rule 108. Okay, so what is this rule? Here, the venue should be in the regional trial court of the province where the corresponding civil registry is located, not where the petitioner resides, no. It's where the civil registry is located, because it is the civil registry should be within the jurisdiction of the court, territorial jurisdiction of the court, for the court to have that authority to authorize, to give an order to the civil register. And first, the petitioner should be any person interested in any act, event, order, or decree concerning the civil status of persons which has been recorded in the civil register. Okay, the petitioner could be a Filipino spouse, it could be a foreign spouse. In that case of Fujiki versus Marina, it was the spouse in the first marriage. She married twice, the first husband Japanese, second husband also Japanese. The second marriage divorced there in Japan, so the first husband wanted that divorce decree be recognized in the Philippines. Okay, and it could also be filed by a Filipino citizen, previously Filipino, who got naturalized abroad and who obtained the decree of divorce abroad. Okay, so next please. Respondent, civil registrar, of course. And all persons who have or claim any interest which would be affected thereby. Next please. Notice and publication. This is the important thing which differentiates from the first, which is differentiated from the ordinary civil action. Here, the court will issue an order setting the case for hearing, and that order should be published. Three successive times in a newspaper of general circulation. Okay? And that should be presented as proof to the court that this notice of publication was done, that the order was published in the newspaper. Next, please. So opposition could be the respondent, it could be any person, and sometimes sometimes somebody could come in, an oppositor. They appear at the hearing, at the date set for hearing, but usually they just appear, and then it's up to them whether they want to continue. But the state here is represented by the Office of the Solicitor General that authorized already the Office of the City Prosecutor to represent the state in the case. Okay, so why? It's hearing and then presentation of evidence. So in other words, this procedure is also adversarial. Okay, it's also adversarial. It gives notice to the public, and then the public can join, can file their opposition, and the state is always there, represented by the Office of the City Prosecutor. Okay, Then now, after the hearing, there will be presentation of evidence. After presentation of evidence, the court may either dismiss the petition or issue an order granting the cancellation or correction prayed for. In either case, a certified copy of the judgments shall be served upon the civil registrar concerned, who shall annotate the same in his record. Okay, so that's how, it's actually not very difficult. You just have a hearing, present all those notices, and then the court will set it for trial, for presentation of the petitioner's evidence. The petitioner will be there, he'll present evidence, and then the opposing counsel will actually be the city prosecutor for the state. Not actually opposing, but they just represent the state. Okay, so, and then the court will thereafter render judgment upon submission of all the documents, or if there's real evidence, and then the testimonial evidence done, the court can render judgment. Okay, next. So, the question now is, what kind of evidence is usually being presented in court? Of course, we have testimonial evidence. The petitioner or a representative of the petitioner duly authorized will testify usually to identify the documents presented and state that indeed there was a divorce. Okay, and second, here you will see an expert witness in Japan law if necessary. I will touch on that later. Okay, there are some cases, I heard that there are some lawyers who are experts in the law of Japan, and sometimes they get to be presented as witnesses in court for them to authenticate the national law of Japan, that indeed they know about it. So they could be presented as witnesses, but not in all cases. Okay, and then documentary here. Next, please. Classes of documents, you can see the word there is public document. Of course, as stated earlier, this rendered by the mayor, rendered by the court, these are public documents. So, written official acts of records of sovereign authority, official bodies, tribunals, public officers, whether of the Philippines or of a foreign country. Next, please. Documents acknowledged before a notary public, except last wills and testaments, documents, public documents under treaties and conventions, and public records kept in the Philippines. Next, please. So how will these public documents be presented in court? Okay, first, the record of public documents, when admitted, may be evidenced by an official publication where a copy attested by the officer having legal custody of the record or by her deputy and accompanied if the record is not kept in the Philippines with a certificate that such officer has the custody. Next, please. If the record is kept in a foreign country, which is a contracting party to a treaty or international convention to which the Philippines is also a party, or considered a public document under such treaty or convention pursuant to paragraph C of 19, the certificate shall be in the form prescribed by such treaty or convention. Okay, I will touch on that later. That's under the Apostille Convention. And the next, for documents in a foreign country which is not a contracting party. So those, you will see how these should be authenticated. You see how specific documentation and authentication is required under our rules on evidence. So you can see the types of documents and the kinds of authority who can authenticate, who are authorized to authenticate those documents. Okay, so it's not that simple. Next, this one also, okay, shall not, is accompanied by certificate or its equivalent may be presented without further proof. Okay, so at least I'll just give you an idea of how specific we are with respect to documents presented in court. Next, how about jurisprudence? Now, what has the Supreme Court said about the law and the rules of procedure? Okay, here, as stated earlier, it's Rule 108 that must be followed. Ordanesa versus Republic. The cancellation or correction of a civil status cannot be done through a petition for recognition under Article 26 of the Family Code, Paragraph 2 of the Family Code, without complying with the requirements of Rule 108. As I stated earlier, Rule 108, because it's a special proceeding, it establishes a status. There must be notice to the public, and it must be adversarial for the state to make sure that all those grounds, as flashed earlier, effect of foreign judgments, they're about fraud, collusion, remember, lack of jurisdiction, those grounds could be raised by the city prosecutor. Okay, next please. Here, I'll go back to Article 26, Paragraph 2, how this was explained, how this was interpreted by the Supreme Court, where a marriage between a Filipino citizen and a foreigner is validly celebrated. Okay, these are the elements. Can we go to the end? Marriage, Filipino and foreigner. Divorce obtained by the foreigner. It should be obtained by the foreigner, not by the Filipino. The spouse, the foreigner is capacitated to remarry. Therefore, the Filipino spouse should be capacitated to remarry. Next, please. So here, how did they interpret that the divorce should be obtained by the foreign spouse? It now expanded, they expanded it, extended it not only to the foreign spouse who can obtain that divorce. It could be obtained by both the Filipino and the foreign spouse. It could also be obtained solely by the Filipino spouse in that country. See the cases of Galapon versus Republic and Republic versus Manalo. Okay, next. These are instances, these are cases that went up to the Supreme Court on these issues. Filipino spouse participated in the divorce proceedings in Japan. So she joined the divorce of her husband. Admitted, it falls under Article 26, Paragraph 2. So it extended that. Next. Filipino spouse obtained the divorce decree abroad. It was not the alien spouse who obtained it, it was the Filipino spouse who obtained it. Okay, yes, Supreme Court said. Morania versus Republic, December 2019. This was penned by the chairperson of the Supreme Court Committee on Family Courts and Juvenile Concerns, Justice Amy Lazaro Javier. She is our chairperson in my committee. Next. A divorce report issued by the Office of the Mayor in Japan is equivalent to a divorce decree. What is this? What does this mean? Remember earlier, effect of foreign judgments that we flashed on screen? Rule 39, Section 48, the subtitle there is effect of foreign judgments or decrees. So that only covers judicial decrees, right? Judgments. What does that mean? Is it only confined to judgments of the court? The Supreme Court said no. They expanded it. A divorce report issued by the Office of the Mayor in Japan is equivalent to a divorce decree, which may be the subject for recognition of a foreign judgment. So they expanded it to include an administrative order of divorce. Okay, what case? Morania versus Republic, also penned by our chairperson. With Professor Beth Pangalangan and I were together with Justice Javier at the Hague Conference. Okay, so next. Rules on evidence. What's the jurisprudence on this? Authentication and proof of documents. In presenting proof before the court for recognition of the Japanese divorce decree, there should be two types of proof that should be presented. First, the divorce decree, proof of the divorce decree. I think the certificate of that was mentioned earlier, notification of divorce, and also acceptance of divorce. We usually get that in court, no? That's usually presented in court. All those presented. And then, how about the governing law of the state where the divorce was granted? That is the second one that they have to prove in court. So two things, the divorce itself and the documents attesting to the divorce. Second one is the national law of the state where the divorce was granted. Why? Because we have to find out if there is really absolute divorce is granted, although it's already of public knowledge now that there is only one country in the world that has no divorce yet. Which country is that? Okay, there's only one country. All the countries in the world have divorce, but we have to know what kind of divorce. Do you give absolute divorce? Diba? There are two types. So that's what we have. So we have to get the national law that states the divorce is granted, is it an absolute divorce or is it not an absolute divorce? And the second that has to be established, the capacity to remarry, which was also flashed on screen earlier. That provision that stated about the woman being pregnant, that was submitted to me in court. And anyway, because the parties were already beyond the age of getting pregnant, so it no longer mattered. But the fact that it said that about capacity, not having the capacity to remarry, the rule therefore is that there is a capacity to remarry. So that was what was presented to me in court, and I granted the petition. Okay, so next, please. Republic versus Manalo. Example, the documents submitted, the decision of the Japanese court allowing the divorce. Second, the authentication certificate issued by the Philippine Consulate General in Osaka of the decree of divorce. I got this from the decision of the Supreme Court, okay? The words there, exact words. And letter C, acceptance of certificate of divorce by petitioner and the Japanese national. Okay, all three. Okay, next please. Next please. What did the Supreme Court say? The Japanese law on divorce was not duly established. It noted, however, that the existence of the divorce decree was not denied, that the jurisdiction of the divorce court was not impeached, nor the validity of the foreign proceedings challenged. Therefore, what did the Supreme Court do? They remanded the case to the court of origin in the regional trial court of Dagupan City for further proceedings, specifically for reception of evidence to prove the relevant Japanese law. Okay? Next, please. Another case. This is Aresa versus Toyo. What were the documents submitted? The divorce certificate, Tetsushi's family register, that was mentioned earlier, the family register. That's why I got familiar with that. And then the certificate of acceptance of the notification of divorce. Okay, and the English translation of the Civil Code of Japan. What happened? What did the Supreme Court say? The Supreme Court said that the regional trial court found the documents submitted to prove the divorce decree complied with the authentication requirements in the rules. So the divorce decree, the acceptance of the divorce, the certificate, all of those complied with the rules, no problem. But however, it found that the copy of the Japan Civil Code and its English translation insufficient to prove Japan's law on divorce, as these were not duly authenticated by the Philippine Consul in Japan or the Japanese Consul in Manila or the Department of Foreign Affairs. Okay? Why? Actually, the Supreme Court, the decision of the RTC that was before the Supreme Court was my decision. The decision in my court, branch 106 of Quezon City, I denied. The petition was denied because there was no sufficient proof of the law in Japan. What was submitted? What was submitted? Next slide, please. Okay, this is what they submitted. The English translation of the Japan Civil Code published under the authorization of the Ministry of Justice. And it was that, they said that the lawyer said that this is an official publication. And therefore, it is a self-authenticating document. It need not be authenticated by the consul, by the DFA, whoever. It need not be authenticated because it is self-authenticating. What did the Supreme Court say? Next. Wait, sorry. Okay, go. Next slide. The English translation was published by the Avon Horatia Incorporated, a private company in Japan, engaged in publishing English translation of Japanese laws, which is the EHS Law Bulletin Series. Is that correct? Is that correct? Private company? Okay. Number 2, these translations are not advertised as a source of official translations of Japanese laws, and they cited in the website. Is that correct? Third, it is the Kanpo, K-A-N-P-O, or the official gazette, where all official laws and regulations are published, albeit in Japanese. It is the Kanpo, right? See? So how can it be self-authenticating when there is no official statement, or not even just a mere authentication, that that is an official publication of the Japanese government. And I went over my decision because the decision was rendered in 2014. Okay, I went over, that's almost 10 years ago. And what happened there? The lawyer showed me a copy of the book, the Civil Code of Japan, 2000, showed me a copy. Oh, this is here, like that, this one. But what is submitted to court were merely photocopies. So not the whole book, but just selected pages. When I went over each page, I could not find any authority there stating that these writers were authorized by with the Japanese government or what. None at all. None. Not even any about their qualifications, none. And the statement authorized by the Ministry of Japan, it's there in the book. Not authorized by the Ministry of Japan. That's there. It's there. But authorized could also mean with the permission of the Japanese government. There is no statement. It is an official translation. None at all. So if you are the judge, you are given something like that from a foreign country, and you have no background about the Japanese law except what's presented to you. Will you think that is a self-authenticating document? What should have been done? There should have been an expert witness who testified and authenticated the document, or that the pages of the book could have been authenticated by the DFA or by the Japanese embassy. Because how would we know that exactly that's a genuine document? That's an authentic document. In the year 2014, no, 2014 was the decision, the presentation was 2013, 10 years ago. See? So, and I got affirmed by the Supreme Court. Twice. Not only in Areza versus Toyo, but also in Medina versus Koike. Twice. So, next, please. So now, with all these things that happened when the Supreme Court gave this decision, when the Supreme Court affirmed the trial court's finding that the documents submitted did not comply with the proper procedure and authentication, did the Supreme Court dismiss the petition? Anything? You know anything about this? Did the Supreme Court dismiss the petition? No. Second, was the petitioner deprived of any other remedy? Yes or no? No also. See? It's actually, there is this mindset that indeed we will give you the opportunity to present that evidence. Next, please. No, correct. Next, please. What did the Supreme Court do in Areza versus Toyo and Medina versus Koike? They referred the case to the Court of Appeals for reception of evidence to determine and resolve the factual issues in accordance with the Supreme Court decision. Because the only issue left there was the authenticity of the Japan Civil Code. Civil Code of Japan. That was the only issue there. The divorce was duly proved. Only now the national law. Only that. Okay, so they just gave it to the Court of Appeals, not back to the trial court. Why not back to the trial court? Because the decision was brought of the RTC was brought directly to the Supreme Court via petition for review and certiorari, Rule 45. In the other cases that they referred the case back to the RTC, the decision was brought on appeal to the Court of Appeals. The Court of Appeals rendered the decision, and it went up to the Supreme Court. So when they remanded it to the case where the court where the case originated, the regional trial court. Okay? So next, please. See? Case remanded to the court of origin for further proceedings and reception of evidence. So the petitioner was given a chance to present now that national law. See how very the court is actually very flexible. You can see that, giving the person a chance to submit the evidence, the proper evidence in accordance with the rules of procedure and the rules on evidence. Okay, Moranya versus Republic, Republic versus Manalo, Racho versus Tanaka. Okay, next. International conventions, Supreme Court circulars, and others. Okay. So the general rule about judicial notice, Philippine courts do not take judicial notice of foreign judgments and laws. They must be proven as fact under our rules on evidence, A divorce decree obtained abroad is deemed a foreign judgment, hence the indispensable need to have it pleaded and proved before its legal effects may be extended to the Filipino spouse. Next, please. So, question is, when can judicial notice be taken? I think this is going to be taken up, delivered by Professor Raj. Okay, I'll just give a run-through of what we have in the jurisprudence. Okay, when can judicial? Oh, well, number one, the Office of the Court Administrator issued a circular. The Administrator issued a circular on June 23, 2022, just last year, stating, and this was addressed to the family courts. Family courts, different from the regional trial courts, family courts. And then compilation of laws. So the Department of Foreign Affairs, upon request of the Office of the Court Administrator, furnished the Office of the Court Administrator with a compilation of several foreign laws on marriage and divorce for reference and use of the judiciary, particularly the family court judges, in resolving petitions for recognition. Next, please. The texts were officially transmitted to the Philippine embassies and consulates by the Ministry of Foreign Affairs. And next slide, please. In view, the family courts, they were advised to take judicial notice of this compilation of the laws of foreign countries on marriage and divorce. So, compilation. Okay, and they can access that on the website there. And that was given to all the family courts. Next. But a few weeks later, they amended that circular. And they changed it now because they realized that it's not the family courts that handle cases for recognition of foreign judgments of divorce. Actually, the recognition of all foreign judgments is not before the family courts. Not anymore. There's a Supreme Court resolution stating that that should be filed with the regular courts, the regular regional trial courts. Okay? So, and they changed it and addressed now the circular to the regional trial courts. To address this matter, the DFA furnished the OCA with a compilation of several foreign laws. And then, for enforcement of the foreign decree of divorce, subject to prevailing jurisprudence and or applicable court issuances related thereto. So those laws that they could access, that would be subject to jurisprudence and the court issuances. Okay? Still the same? Next, please. And it states there, this supersedes Office of the Court Administrator Circular, number 157-2022. It supersedes. The word judicial notice is already taken out, if you have noticed it. But the website is still there. Okay, next please. So, next please. So, can we avail of that? Yes, it's on the website, but still there is no statement there that the court should take judicial notice. And take note that this is an administrative circular. For us to take judicial notice, whether mandatory or discretionary, mandatory, no? If you want mandatory, it should be enclosed. It should be in a Supreme Court resolution signed by all the members of the court en banc. Or it should be part of the rules of procedure. I think they're doing now the pleadings and practice, the rules. Okay, so self-authenticate. So what could be a fallback? If we cannot follow that circular of the Office of the Court Administrator, what's our fallback? We can try the self-authenticating provision, that was mentioned earlier in Aresa versus Toyo. It should be self-authenticating. It could be published by your official gazette, by CANCO. Will CANCO be publishing an English translation of all your laws? Will the government be publishing an English translation? No. Okay, if there will be something like that, we can avail of that. Okay, and how about if that could be authenticated by an expert witness, why not? Or it could be authenticated by the lawyer himself who already went to Japan and took an LLM course there and is very familiar with Japan law, right? I had one case, the lawyer himself, because he took his LLM in Japan, the counsel for the petitioner himself testified. He just got another lawyer to give him the direct examination to prepare his judicial affidavit and for him to authenticate that in court. But cross-examination was conducted by the city prosecutor. See, and he authenticated the document. See, it could be done that way. So, take note, however, I have to raise this, no? Republic versus Bayog Saito, August 17, 2022. This is what the Supreme Court said. The English version of the Civil Code of Japan, translated under the authorization of the Ministry of Justice and the Codes of Translation Committee, is sufficient. So this is different from Aresa versus Toyo. Different. And, but I want to stress, Rivera versus Republic and Basa Egami versus Barsales, they followed the ruling in Aresa versus Toyo. Okay, take note, that's July 6, 2022. Basa Egami, that's the latest. But then the later one is Republic versus Saito, August 17. So it's 1 month after. Okay? But Republic versus Saito was promulgated by the 3rd Division of the Supreme Court. Aresa versus Toyo was promulgated by the 2nd Division of the Supreme Court. Basa Egami versus Bersales was promulgated by the 2nd Division of the Supreme Court. So the 1st and the 2nd Divisions of the Supreme Court, Aresa versus Toyo. 3rd Division, Republic versus Bayog Saito. Okay? So what should be done? Let's see what's gonna happen. Okay, next please. Learned treatises, this was also raised. How about making it a learned treatise? Okay, this was raised in Aresa versus Toyo. And look, a learned treatise is a published treatise because they wanted the Civil Code of Japan to fall under this one. Okay, the English version. A published treatise, periodical, or pamphlet on a subject of history, law, science, or art is admissible as tending to prove the truth of the matter stated therein if the court takes judicial notice, or a witness expert in the subject testifies that the writer of the statement in the treatise, periodical, or pamphlet is recognized in his or her profession or calling as expert in the subject. So 2 things. It could be presented in court, the judge can take judicial notice of that. What kind of judicial notice? Discretionary. It's not mandatory, it's discretionary. Discretionary depends on several circumstances that would make the judge indeed know that that is authentic, that is genuine, that is authentic. That document is authentic. And, or a witness can be presented, an expert who can testify, yes, that document is authentic because of the background of the witness, he studied in Japan or whatever. See? So why do we need this? Because we have to know that indeed those documents are genuine. Those documents are authentic. You know the reason why? I don't want to go into that anymore, but you know the reason why. We have to establish that authenticity. Next, please. Of Apostille Convention. Okay, next, please. This is the pre-apostille. So as I said earlier, the divorce decree has already been the effect of foreign judgments has been extended by the Supreme Court. And now for the procedure of the documents, authentication and proof of the documents, this has been already reduced. The requirements have been reduced by the Apostille Convention. Look at the pre-apostille. First, for the public document is executed in the state of origin. First, authentication by the Civil Registry of the state of origin. Second, authentication by the Justice Ministry of the state of origin. Third, authentication, Foreign Ministry of the state of origin. Fourth, authentication by the Consulate of the state production located in the state of origin. Fifth, authentication, Foreign Ministry of the state of destination. Sixth, authentication, fifth, after the fifth authentication, then it is presented in court. So five people it has to pass through that process. 5. And that's what we call the red ribbon. You're familiar with that, no? The red ribbon is presented in court. That's before the Apostille Convention. Now with the Apostille. Next, please. Very simple. Executed in this public document, executed in the state of origin. The apostille is now issued by the competent authority in the state of origin. And then the document is ready to be produced in court. Okay, I got this diagram, this table from the Department of Justice's presentation during the Asia Pacific Week 2022 here in the Philippines, in Manila last year. Okay, where Professor Pangalangan was part of the organizing committee and also a speaker, both of us. So see how simple it is now. It's no longer as difficult as it was before. So there are two things, extended already, and then the procedure also simplified. Next, please. So I want to mention about this also, because under judicial notice, we have the International Child Abduction Convention. I think the first speaker is a member of the, part of the IHNJ, International Hague Network of Judges, because I'm a member of the IHNJ. And it says there, when the Philippines acceded to the 1980 Child Abduction Convention, the International Hague Network of Judges, IHNJ, is anchored on the 1980 Child Abduction Convention. When we made the rule of procedure, we saw this in the convention itself, that the requested state may take notice directly of the law of and of judicial or administrative decisions. It's there in the convention itself. So when we acceded to it, we had to include that provision in our rule of procedure. Next, please. This is our rule of procedure. You can see Section 11, the child abduction, AM administrative number 22-09-15-SC. You can see the last paragraph of Section 11. For this purpose, the courts may take direct notice of the relevant laws and decisions of other contracting states without need of the parties to prove said laws and decisions according to the ordinary rules of evidence. Because this is anchored on the Child Abduction Convention. Which convention the Senate of the Philippines concurred in, and that is required under the Constitution. International treaties, conventions need Senate concurrence, 2/3 of the Senate, and this convention, there is Senate concurrence to this. So it's part of the law of the land. That's why when we prepared the rule of procedure, we had to include this. And I'll mention this again, Professor Pangalangan was our resource person. Okay, and we also prepared the rule on child support, family maintenance, based also on the Support and Maintenance Convention, International, HCCH on private international law. Professor Pangalan was also our resource person. Next, please. So, to summarize, the first, Article 26, Paragraph 2 of the Family Code has been expanded by the Supreme Court decisions. Number 2, if Rule 39 does not only cover judgments and decrees, judgments and orders, court orders, it also covers orders issued by the administrative agencies authorized by the government of that state, duly authorized. The third, about judicial notice, yes, that will be explained by Professor Braj. And then proof of documents, that will also be explained. So I hope I was able to state how everything is now here in the Philippines, what we have already done for the past how many years. Okay, so I'd like to say thank you very much again for being here. Maraming salamat po. Next, please. Arigato.
Thank you very much, Justice Kimposale, for that amazing and comprehensive presentation. Now we move on to our next speaker and our next presenter, who is a full professor of the UP College of Law and the author of several books on family law and private international law. She is the Philippine representative to several international bodies, including Experts Group and Working Group on Parentage and Surrogacy of the Hague Conference of Private International Law from 2016 to the present. In October, she began her 3-year term as a Philippine representative to the ASEAN Commission on the Promotion and Protection of the Rights of Women and Children, or ACWC. She has likewise been designated by the Supreme Court as amicus curiae in a case on recognition of foreign divorce, which will be heard by the court within this year. She is also currently serving as the president of the Philippine Society of International Law. Ladies and gentlemen, our speaker on Philippine legal effects of foreign divorce, Professor Elizabeth Aguiling Pangalangan. A round of applause, please.
Okay. Oh, thank you. Good morning, everyone. Thank you for the generous introduction, Jamie. So, Justice Sally just made my work easy because there were some overlaps in our presentation, so I won't have to go through that. And I think you will appreciate that fact because it's almost lunchtime, so I'm sure that there's something else we'd like to do other than to listen for long to our presentations. So the first thing that we have to remember is the applicable law. What law will apply for issues pertaining to family rights and duties, status, conditions, and legal capacity. And we find that in Article 15 of the Civil Code, which says that Philippine law will apply even if the citizens of the Philippines have been residing abroad. And this is, I would say that this is very important, especially if one realizes that the Philippines has somehow encouraged Filipinos to go abroad as overseas Filipino workers to find more opportunities. And yet, for as long as they remain Filipino citizens, then they are bound by Philippine laws on all matters pertaining to family rights and duties. So there you see a fertile ground for all of the cases that Justice Saleh mentioned. Now, another provision of importance is Article 26, second paragraph, which was already discussed. And this pertains to a marriage between a Filipino citizen and a foreigner, and then there's a divorce thereafter, capacitating the foreigner to remarry. Then the Filipino spouse shall likewise have the capacity to remarry under Philippine law. Justice Saleh made reference to the interpretations, expansions, extensions made by jurisprudence on this rather short article, Article 26, second paragraph. So briefly, we first see that in Kita versus Dandan, by way of obiter dictum, the court said that we deduce that the finding on their citizenship pertained solely to the time of their marriage, as the trial court was not supplied with a basis to determine petitioner's citizenship at the time of their divorce. So in this case, Fed just said that she filed for divorce in 1954, and in some other questions she said also that she became a naturalized American in 1954. So the court said that the trial court must have overlooked the materiality of this aspect. Once proved that she was no longer a Filipino citizen at the time of their divorce, Van Dorn, an earlier case decided in 1985 before the family code came into effect, would become applicable, and petitioner could very well lose her right to inherit from Arturo. So again, just by way of obiter, the court here is saying that let's find out which came first, the naturalization or the divorce, because if she was naturalized already by the time she filed for divorce, then by that time she was already a foreigner, and the divorce would be valid and would bind her, and therefore she will lose the right to inherit from Arturo. In Republic versus Ioy, decided in 2005, the court said that as it is worded, Article 26, paragraph 2 refers to a special situation wherein one of the couple getting married is a Filipino citizen and the other a foreigner at the time the marriage was celebrated. Indeed, if you look at Article 26, it talks about a Filipino and a foreigner whose marriage is validly celebrated. Therefore, at the time of the celebration of the marriage, one must already be a Filipino and the other a foreigner. By its plain and literal interpretation, the court held, the said provision cannot be applied to this case. At the time she filed for divorce, Feli was still a Filipino citizen, and pursuant to the nationality principle embodied in Article 15 of the Civil Code of the Philippines, she was still bound by Philippine laws, which then and even until now do not allow and recognize divorce between Filipino spouses. Thus, Feli could not have validly obtained a divorce from respondent Crasus. In Republic versus Orbicido, decided just a month after Ioy, the issue before the court was whether the same principle applies to a case where at the time of the celebration of the marriage the parties were Filipino citizens, but one of them later obtains a foreign citizenship. So in Ioy, the court said that at the time of the marriage, one must already be a Filipino and the other foreigner. So in Orbicido, the question was, what if at the time of the marriage, both were Filipinos, but subsequently one becomes a naturalized citizen of any country, because in any of those countries, divorce would be valid. So the Supreme Court took note of the legislative intent behind Article 26, paragraph 2. And the court said that this was to avoid the absurd situation where the Filipino spouse remains married to the alien spouse who, after obtaining a divorce, is no longer married to the Filipino spouse. So the court said that on its face, Article 26 does not appear to govern this situation, but taking into consideration the legislative intent and applying the rule of reason, we hold that paragraph 2, Article 26 should be interpreted to include cases involving parties who, at the time of the celebration of the marriage, were Filipino citizens, but later on one of them becomes naturalized as a foreign citizen and obtains a divorce decree. So you see here that from the plain interpretation, the earlier mentioned, no, plainly, directly just by looking at the words of Article 26, paragraph 2, one must be a foreigner, one a Filipino at the time of the marriage. And the court said here, yeah, but what's the reason behind the law? That's what we follow. And therefore, it's not the citizenship at the time of the marriage, but the citizenship at the time of the divorce, no, which will determine whether there was a valid recourse to divorce. And then, again, mentioned already earlier, in 2018, the court further expanded the application of Article 26, paragraph 2, by saying that, again here, claiming that it is clear and plain reading. All the cases claim it's clear and plain reading, but the decisions and the interpretations differ. So one wonders, no, if it's so clear and plain, why are there so many changing or evolving interpretations? But the court said that on a clear and plain reading of the provision, it only requires that there be a divorce validly obtained abroad. The letter of the law does not demand that the alien spouse should be the one who initiated the proceeding wherein the divorce decree was granted. It does not distinguish whether the Filipino spouse is the petitioner or the respondent in the foreign divorce proceeding. The court is bound by the words of the statute. Neither can we put words in the mouths of the lawmakers, and that somehow I think that they did, no? Because the court said here that the term a divorce validly obtained abroad, obtained does not mean initiate. And so it doesn't matter who filed, for as long as a divorce was obtained, then that falls under Article 26, second paragraph. Although I point out to my students at the UP College of Law that if that were so, then perhaps this paragraph should not have continued into obtained abroad by the alien spouse. It should just have said a divorce validly obtained, capacitating whoever to marry, no. But it says here obtained by the alien spouse, and that the court said no, it doesn't mean filed or initiated by the alien spouse. And so now, I actually agree with the result, although I had hoped that this would the result, because even in my writings and lectures in the past, I always pointed out that in all other decisions which are sought recognition in the Philippines, you don't look at who filed what, right? So why is it that in divorce we look at who filed? So, and I also brought up situations where, for instance, the Filipina is a victim of domestic violence, then she can never file for divorce. It has to be the foreigner. And I thought that that was unfair, no? That this was, in fact, in violation of our laws protecting women and anti-vowsy and others. So the result I agree with, although I thought that the better way was for a legislation that would clearly change this law. Okay, recognition of foreign divorce and capacity to remarry is one of the effects of foreign divorce. This is the assignment that Professor Raj gave me. Make sure you discuss this. So, okay, I will try, Professor Raj. Okay. So Morisono v. Morisono, in this case, Luz Viminda was married to Morisono in the Philippines. They lived together in Japan for more than a year. However, the marriage was unhappy, and soon enough, they filed for a divorce by agreement. Luz Viminda, and this was approved and duly recorded with the head of Mizuhoku, Nagoya City. Luz Viminda filed a petition for recognition of the foreign divorce decree obtained by her and Ryoji before the RTC so that she could cancel the surname of her former husband in her passport and for her to be able to marry again. I'm not even sure, did I say this right? Is it called a divorce decree, even if it is a divorce by agreement? But anyway, the issue is whether or not the RTC correctly denied Luz Viminda's petition for recognition of the foreign divorce decree because she filed. She also filed together with the husband for the divorce by agreement. And the ruling made a distinction between the recognition of the judgment and the legal effects. The court held that under the principles of comity, our jurisdiction recognizes a valid divorce obtained by a spouse of foreign nationality, but the legal effects thereof, such as custody, care and support of children, property relations of spouses, must still be determined by our courts. So that's one important thing. So sure, we will recognize the foreign judgment, but the effects, not necessarily. We still we still can look into that and in fact change it. However, the court cannot just order the grant of petition because Luz Viminda yet has to prove the fact of her divorce by agreement and its conformity with prevailing Japanese laws on divorce. The court also held that in mixed marriages involving a Filipino and a foreigner, the former is allowed to contract a subsequent marriage, the Filipino that is, in case the absolute divorce is validly obtained abroad by the alien spouse, capacitating him or her to remarry. So this is still the more textual reading of Article 26. So another interesting case, quite recent, is the in re recognition of foreign judgment of divorce with prayer to change civil status of Jane Vic Ordaneza. Here, Jane Vic, a Filipino, married a Japanese Imura, and later they obtained a divorce decree by agreement from Japan. Jane Vic, through her brother, filed a petition for judicial recognition of foreign divorce and that her status, civil status, be changed from married to single. I'll go fast. The ruling of the court here was that the divorce by agreement severed the marital relations between the spouses and the Japanese spouse is capacitated to remarry. Moreover, the official document Jane Vic submitted to prove the fact of divorce, the divorce notification, did not indicate any restriction on the capacity of either spouse to remarry. Therefore, the court deems it prudent to adopt its ruling in Racho, which involved the same foreign law, in holding that the capacity to remarry of the foreign spouse has been established. The court further said that the petition of Jane Vick is granted, however, only insofar as the first part. This was recognition of foreign judgment with prayer for change of civil status from married to single. So the court said, oh, the first part we grant, but the second part, no. Married to single, then, as Judge Sally was saying, this has to follow Rule 108 procedure. Okay, another effect is custody of children. Under Japanese law, Article 819, if parents divorce by agreement, they may agree upon which parent shall have parental authority in relation to a child. And yet, if we consider the family code, Article 213, it says that in case of separation of the parents, parental authority shall be exercised by the parent designated by the court. The court shall take into account all relevant considerations, especially the choice of the child over 7 years of age, unless the parent chosen is unfit. And then the next paragraph is what we call the tender use presumption, or the maternal preference rule, which states that no child under 7 years of age shall be separated from the mother unless the court finds compelling reasons to order otherwise. So below 7, it is mandatory. The general rule is recommended in order to avoid a tragedy where a mother has seen her baby torn away from her. No man can sound the deep sorrows of a mother who is deprived of her child of tender age. So the exception to this is that it has to be for compelling reason. But the court said that, citing the Code Commission records, it said that these cases must indeed be rare if the mother's heart is not to be unduly hurt. So you see that the tender use presumption is for the protection of the child. The law, Philippine society believes that at a tender age, it is only the mother who can give the love that the child needs. So it is in the best interest of the child that the child stays with the mother. But at the same time, it also looks at the interest of the mother because they don't want the mother to be unduly hurt. And the report says, if she has erred, as in cases of adultery, the penalty of imprisonment and relative divorce or legal separation will ordinarily be sufficient punishment for her. Moreover, the moral dereliction will not have any effect upon the baby who is as yet unable to understand the situation. So even if this could be a ground for legal separation, that's between the husband and wife. It does not necessarily affect the relationship of the mother and the child. Our law recognizes the right of parents to the custody of their children, but courts must not lose sight of the basic principle that in all questions on the care, custody, education, and property of children, the latter's welfare shall be paramount, and that for compelling reasons, even a child under 7 may be ordered separated by the mother, from the mother rather. But again, this is mandatory. The word used is shall, so a child below 7 shall not be separated from the mother. However, we mentioned, unless there are compelling reasons and the court has rendered a mother unsuitable to have custody of her child based on neglect, abandonment, unemployment, immorality, habitual drunkenness, drug addiction, maltreatment of the child, insanity, or affliction with a communicable disease. I find that interesting, the last part, like, oh, why is that there? But anyway. Here, the court said the mother was not shown to be unsuitable or grossly incapable of caring for her minor child. All told, no compelling reason has been adduced to wrench the child from the mother's custody. Another effect is support. The Family Code says that subject to the provisions of the succeeding articles, there is an order upon which the obligation to support is placed. First, the spouses. Second, legitimate ascendants, descendants, and then parents and their legitimate children, and the illegitimate children of the latter, etc. But what's pertinent to us is number 3. Therefore, I don't know how it is in Japan, but Philippine law says that even after legal separation, there is a duty, the duty to support one's spouse may cease but there's the duty to support children continues. So I don't know if in Japan that is the same, no? Because I, although I heard one of the speakers say that it ceases, so I would appreciate an explanation, clarification on that. So the duty must continue because the children will continue to have their needs. One international instrument that could be helpful is the Hague Convention on International Recovery of Child Support. The purpose of the convention is to ensure the effective international recovery of child support and other forms of family maintenance. Here, there is a central authority in the Philippines and in each of the countries who signed the convention, and the requests for maintenance can be coursed through them. However, although the Philippines has already acceded to the convention, Japan hasn't, so we cannot use this, but otherwise it would really be helpful, no? Another effect would be the dissolution and liquidation of the property regime in accordance with the divorce notification or other document evidencing divorce. But if there are properties in the Philippines, there is a constitutional prohibition on ownership by foreigners of land. The Constitution's Article 12, Section 7 says that, sorry about that. Oh. I don't know what I did. Save in cases of hereditary succession, no private lands shall be transferred or conveyed except to individuals, etc.
Private international law. Everyone, our speaker on Philippine Judicial Notice of Foreign Laws on Marriage and Divorce, Assistant Professor Andre Palacios.
Thank you, Jamie, and thank you very much, Justice Kim Posale and Professor Beth Pangalangan, for your excellent presentations. I am here with this unenviable task of giving a presentation after the presentations of giants in the field, no? Experts not only here in the Philippines but also internationally. I hope that I will not earn the ire of my former family law professor and a sitting Court of Appeals justice, no? I will not be held in contempt for what I will be saying. I will be addressing the problem which was discussed by Justice Kim Posale regarding proof of foreign law. Okay? So next, please. As Justice Kim Posale said, a procedure for recognition of foreign divorce aims to prove two things. Number one, the divorce decree, and the national law, the foreign divorce law. This is based on the second paragraph of Article 26 of the Family Code. Next, please. So the first fact that needs to be proven. So these are matters of fact. Even though it's a law, the foreign law will have to be proven as a fact. Okay, so first would be the foreign law. It would go into the content of the law to show that it allows divorce. And it also have to show that the foreign law capacitates the alien spouse to remarry. The second fact will be the fact of the foreign divorce. And there it will have to be shown that the foreign divorce was validly obtained or obtained in conformity with the foreign divorce law. Okay, next. So now the bigger question of how to prove these foreign facts. Okay? As mentioned in the case of Republic versus Kikuchi, the two foreign legal facts, foreign divorce and foreign law, are official written acts of a foreign sovereign, and therefore they will have to comply with the requirements of Section 24, Rule 132 on presentation of evidence in the Rules on Evidence. Next, please. So the Rules on Evidence provide in Section 19 that this type of document is a public document, and in Section 24 says that they can be proven either through an official publication or an attestation copy. Okay, next, please. So there are two options for proving these foreign legal facts. One is by obtaining an official publication of the foreign law. We'll be focusing on foreign law, no? Not on the foreign divorce decree. And I understand in Japan, you have the equivalent of the official gazette, but the publication is in the Japanese language, right? The second option for proving the foreign law would be by obtaining a copy attested to by the legal custodian of the record. And because it is issued in a foreign country, there will have to be one of two possible documents. Next, please. It could either be an apostille, if the country from which the document originates is a party to the Apostille Convention, or if the state from which it originates is not a party, then it will be a certification issued by the Philippine consul. So, two options to prove the foreign law, an official publication or an attestation copy. Okay, next please. Okay, so let's look first at the second option, an attestation copy of the foreign law issued by the legal custodian. Okay. In the case of Medina versus Koike, the petitioner submitted a photocopy of a Japanese civil code with an English translation and two English language books on Japanese civil code. So the Supreme Court said the foreign law was not sufficiently proven, and so they had to remand the case to the lower court. In Noliada versus Civil Registrar, what was submitted was a photocopy of an English language book on Japanese civil code with the stamp Japanese Embassy Library, probably published by, this was the publisher previously mentioned by Justice Kimposali, Avon Horei Sha, a private publishing company. Also remanded because the foreign law was not sufficiently proven. Moranya versus Republic, printed pages of the website on Japanese civil code plus an English translation. Again, not sufficiently proven, remanded. Next, please. Kondo versus Civil Registrar General, English translation of a civil code, authenticated. Again, not sufficient, remanded. Republic versus Kikuchi, photocopy of an English language book, again, published by Avon Horei Sha, again, remanded. Next, please. Basa Egami versus Bersales, again, a book by Avon Horei Sha, plus certification by the Japanese, I think he's from the Osaka Legal Affairs Bureau. He notarized it and certified it, but still deemed to be insufficient, again, remanded. Okay, next please. So this is a a copy of the book which was used by the petitioners when they submitted their, in support of their petition. So this is the book entitled Civil Code of Japan. It's English language, published by Avon Horei Sha. And the notation on the inside back cover of this book, which Justice Kim Posali pointed to, was this. No? Next, please. It was issued under authorization of the Ministry of Justice and the Codes of Translation Committee whose official translations are contained herein. So, does this qualify as an attestation copy? Obviously, it is not, right? Because it was not issued by the legal custodian of the record. Is it an official publication? Well, let's see. Next, please. The first option is to use an official publication of the foreign law. And we know that the official publication of the foreign Japanese law, the Japanese divorce law, is in the Japanese language. But in Racho versus Tanaka, what was submitted was probably the same book that was deemed insufficient in other cases. And there, in Tanaka, Racho versus Tanaka, the Supreme Court said it is sufficient, and they granted the petition. Okay, so there seems to be a difference in the appreciation of the same document. Next, please. In Republic versus Bayog Saito, again mentioned by Justice Kim Posale, the Supreme Court again deemed this same book as sufficient basis to prove the foreign law. The petition was granted. Next, please. This was a case that Justice Kim Posale mentioned. I think she was the judge in this case. And here, the Supreme Court said, this book by Avon Horatia, a private printing company, is not an official publication. So we had some discussions before. We're saying it seems that the Supreme Court decisions are now clear as to the type of documents required to prove the foreign law. But as it turns out, it's not very clear. No? So is the book an official publication of the foreign law? In Areza, the court said it is not. Okay, next please. And this was confirmed by the Japanese embassy here in Manila, where the Japanese embassy said, the law of Japan is in the Japanese language, right? And there is no official English text of the law of Japan. Okay, next please. So, I have two proposals. One is the use of, and please, I would solicit your comments on this, no? First is the use of certified attestation copy and translation. Okay, so as we said, there are two ways for proving the foreign law. Number one, official publication, which we won't use. And the second one is the use of an attestation copy. Okay, so here, we'll use the attestation copy. So first step is to comply with Rule 132, Section 24. Next, please. So we need to obtain a copy of the foreign language statute, the Japanese statute. It will be in Nihongo, attested by the officer having legal custody, plus an apostille of the Japanese language document. The third document will be the English translation by an expert. Right? It could be, Ministry of Justice or whoever, right? And the OCA may obtain these with DFA assistance. Now, previously, Justice Kim Posale mentioned already the Office of the Court Administrator, Circular 157, issued in the year 2022. And there, the Office of the Court Administrator described the efforts of the OCA to gather these documents, the text of foreign laws regarding marriage and divorce. So the OCA already has these compilations. No? But I noticed that the manner of obtaining these documents was submissions in the form of notes verbal by the foreign embassies. So it was not an attestation copy issued by the officer having legal custody. So if you apply Rule 132, Section 24 strictly, to the documents that are now in the possession of OCA, maybe some of them may not comply with Section 24 because they are not an attestation copy issued by the officer having legal custody of the record. Okay. Next, the next step would be for a public officer to take custody of these attestation copies and with the apostille and their translations. The Supreme Court may authorize the OCA to take custody of the attestation copy, the apostille or consular certification, as well as the translation. So it will be OCA, which will be acting as the public officer having custody of these attestation copies and related documents. Next, please. Then, the litigants may go to the OCA, OCA being the public officer authorized by the Supreme Court to take custody of these attestation copies, and request the OCA to provide certified copies of the attestation copies for use by the litigants in their cases. What is the authority to use certified copies in cases? This is found in Rule 130 of the Rules of Court pertaining to admissibility. Section 8 authorizes the use of certified copies of documents in the custody of a public officer. Okay, so the original copy of the attestation copy will remain with the OCA, but the OCA may issue certified copies. Next, please. Periodically, the OCA may wish to monitor whether there are any changes in foreign law, and the OCA may do this with the assistance of DFA. So this is the first proposal, the use of certified copies of the attestation copy that will remain with the OCA. Okay, next, please. The second proposal, this was discussed also by Justice Kim Posale, pertains to judicial notice. Again, we comply with Section 24 of Rule 132, where the DFA probably, upon the request of OCA, may go to the foreign legal officer having custody of the original of the foreign law, and then obtain an attestation copy from that foreign legal officer abroad. And then we add the apostille or certification, and then we have the foreign language document translated by an expert. Step 2. Next, please. The judiciary may, if possible, publish the documents, the compilation of the English translations as well as the foreign language documents, attestation copy, as the official act of the judiciary. Okay? The Supreme Court itself or the OCA, upon authority of the Supreme Court, may publish the documents as its official act. This is not far-fetched. These documents are actually already found today in the website of the Supreme Court. Probably what we just need is for the Supreme Court to characterize this publication as the official act of the judiciary. And step 3, judges may then take judicial notice of the official act, the published documents. Judges taking judicial notice of official acts of the judiciary is authorized under Rule 129 of the Rules of Evidence, which provides that a court shall take judicial notice without the introduction of evidence of official acts of the judicial department of the national government. Next, please. And then the OCA may wish to do periodic monitoring for any changes in foreign law. So I end here, and I would like to I solicit your comments on these two proposals. Thank you very much.
Thank you very much, Attorney Raj. In the interest of time, I know that we're running a little bit behind our schedule. We'll open the floor to 2 questions. Masao-san will assist us in answering for the speakers to answer the questions. But do we have questions from the floor? Yes. Can we have a microphone over there, please? Please identify your name, your organization, and specify who you are directing your question to. Thanks.
Hello, good afternoon. My name is Attorney John De Guia from David and De Guia Law Offices. And my question pertains to proving foreign law. Because I think it was Professor Palacios who mentioned that the OCA Circular 157 and the proposal that it might be good for the Supreme Court or OCA to issue a publication stating that there should We're arguing this with the regional trial court at the moment, and we have a case on the Court of Appeals now, specifically targeting the wording of subject to prevailing laws and jurisprudence, because what we're not sure is the OCA circular referring to the possibility of a change of the law of Japan or other national laws? Or is the OCA circular referring to a change in jurisprudence as to the matter of proving those foreign laws? So I'm addressing this in particular to Professor Palacios, but maybe any other speaker would have some thoughts on this.
Thank you. All right, thank you. Can we get one more question? If none, then, oh, yes, ma'am. Can we please get a...
Thank you very much. I'm Sadia Sultana. I did my PhD in international law. I'm from Bangladesh, but I reside in the Philippines for last 11 years. Just out of curiosity, after hearing the presentation, I would like to know how it works in Philippines to enhance my knowledge. Like, if there is a codified law on foreign marriage and dissolution of marriage and inheritance, so the codified law would prevail, but what if there are strong case laws or precedents? Will that be taken into consideration for any conflicts or difference of opinion? How does it work in Philippines, particularly for family laws?
Sorry, just to clarify, you are asking there is a codified...
meaning like the main law is there, but does
Philippine law, you mean,
yeah,
ma'am?
Philippine law, like the civil code or the family code, but does Philippine court take consideration of strong case laws? We call it precedents. In case there has been a dispute in opinions and judgments, how does it work? Which one takes preference?
All right, thank you. I think Justice Kimposale would be able to address that. Can we please first have the esteemed Justice to answer the questions? Thank you, ma'am.
Yes, I think Professor Pangalangan would be in a better position to answer your question.
Justice Sale, well, what happens is that our civil code says that interpretations, decisions of the Supreme Court becomes part of the law of the land. So it's binding. So even if we disagree with the way the court may have interpreted a provision of law, we are bound by that interpretation until there's a change subsequently also. Oh, now you can say something.
It's general. Because the Philippines is a civil law country. It's not a common law country. Common law countries, they're bound by jurisprudence, practices, right? Civil law itself, the law itself. However, in the civil code, some parts of the civil code have been retained. All those parts except on family law, which is under the family code now. There's a provision there that states judicial decisions shall form part of the law of the land. So we're civil law, but because of that particular provision in the law itself, in the civil code, we also have to recognize that. Okay, thank you.
Thank you, Professor. Thank you, Justice. And to answer our first question, may I call on Assistant Professor Palacios?
Sir, thank you for that question. I understand it's a live case, you know. So this issue we're talking about is not academic. Really, it's affecting lives of people. So I think the effect there in the issuance of OCA saying our family courts are enjoined to take judicial notice, actually the OCA probably would not have that authority, you know, to compel courts to take judicial notice of factual matters, because the rules on which matters can be the subject of judicial notice are stated in the rules of court. But it's there, as Oka said it. So for me, we need just to find a way. That's why my proposal number 2 was to find a way to fit the compilation into the existing provisions of the rules of court. So I wish you well in your case.
Thank you. Okay, we have one more question. Can we get a microphone for our guest over in front?
Hello. Thank you very much to our speakers, expert speakers. I'm Attorney Pinky Bernabe from IBP Bulacan and the International Pro Bono Alliance. My question is as regards foreign law and foreign judgments, which are already, as we know, in some jurisdictions, they are already available online. And these online sources are also said to be official sources of the law, I mean, officially recognized in their own country. So my question is it self-authenticating? Or do we recognize these official sites proclaimed by their governments as such, as having official custody of the law? And what, if not, for example, it is this copy of the law is downloaded. What else should be done in order to further authenticate it?
Thank you, Attorney Pinky. Who among our panelists would like to address the question? I think Justice. Thank you, Justice, for taking
Well,
this
I
up.
would like to answer the question, but since it's similar to the very first question and the case is pending before the Court of Appeals. The first question about, it pertains also to those uploaded there in the website by the Office of the Court Administrator. If the case is before the Philippines and you access that law from the official website from abroad, we still have to follow the rules of procedure in the Philippines, unless there is a treaty between this country and that country regarding what I mentioned earlier about the Hague Convention. There is direct notice. If that party acceded to the convention and the case is here before the Philippines, we have a rule on international child abduction cases. We can take direct notice of that rule, provided it should still be authentic. The sources should be stated therein. Why? Put yourselves in the shoes of the judge. How will you know that that is authentic? How will you know it? You need information. You need something that will make you believe that that's genuine, that's official, right? You try to understand that mindset. You need something to prove it. Okay, so what are the rules of procedure in the Philippines? Let's follow that. Okay, if you want mandatory, I think that's what Professor Raj wants, mandatory judicial notice. Well, I don't want to go into that anymore because there's a case pending in the Court of Appeal.
Sub judice. Thank you very much, Justice. We actually have two questions from online, and they're addressed to our Japanese panelists. May I ask Masao to please share the questions?
Okay, thank you. And we have several questions from Zoom participants, but unfortunately we cannot entertain everything due to the time constraint. So I picked the two questions that probably are relevant to Japanese speakers. The first one is, to simplify it, in US and Canada, Filipina or Filipino can file a divorce even though they are not the citizens of the countries. Can a Filipina or Filipino in Japan do the same? That's the first question. And the second one is, I don't understand how Filipino citizen can be bound by Japanese divorce by agreement. And although that our answer could be, it is possible, but the person is wondering how, because he or she thinks that the Filipino citizen should be bound by the laws of the Philippines. So either Taka or Yamara-san, please.
I can answer first one. Then if the Filipina is not living, she doesn't have the habitual residence in Japan, then she cannot file a case to the court in Japan. So literally it's impossible to get divorced in Japan.
Thank you, Attorney Yamara. So can I just clarify that even though the couple live in Japan and both spouses are in Japan, a Filipino spouse cannot file a divorce?
sorry, a misunderstanding. So in that case, like if Filipina is outside Japan, then but the husband is living in Japan, then it's possible to file a case to the court. But she has to hire the attorney for the case because she's not living in Japan. Like she cannot attend the court hearing.
Okay, thank you. And in case if both of the couple live in Japan, can a foreign or Filipino spouse file a divorce or even file a divorce by agreement by herself?
Yes, both possible.
Thank you very much. And for the second question, maybe Taka. The second question is to reiterate. I don't get it. Why a Filipino citizen should be bound by divorce by agreement? Because that's under Japanese law. And the person asked the question thinks that the citizen of the Philippines should be bound by the Philippine law in relation to divorce or marriage.
Yeah, that's a good. Yeah, how should I say? Like, yeah, of course. But if Filipina cannot get like capacity to remarry in Japan, like I think there might be like a observed situation where the one spouse cannot, even though Japanese spouse can remarry, but Filipina cannot get remarried.
Thank you, Taka. And but I think the question is, in the first place, why Japanese law governs marriage that Philippine citizen is a party to?
So we first look at the applicable law code in Japan, and that application law in Japan says that one of the couple is a Japanese citizen. We can use a Japanese law to govern that divorce. So we apply the Japanese civil code, and the Japanese civil code allows divorce by agreement. So the Filipino couple, one of the couple is Philippine citizenship. We can use Japanese law, and divorce by agreement is effective in Japan.
Thank you very much. So the law, Japanese law is clear that the foreign nationals will also be bound by Japanese family law under certain circumstances.
Yes, one of the couple is Japanese citizenship. We can apply the Japanese law. It is clear.
That's the requirement. So as far as one of the spouses is Japanese, then the Japanese family law still applies to a Filipino citizen or any foreigners. Thank you so much.
Thank you so much. And let's give a round of applause again for all our panelists for this morning. It has indeed been a very interesting discussion. With that, we wrap up our panel, and I call back to the stage Attorney Palacios to also recognize and give tokens to our speakers. Thank you.
Okay, apologies for the long delay. I'm sure you're now very hungry. We will move our presentation of certificates of appreciation after lunch. So right now we'll take a break, and we will resume at 1:45 for the part 2 of our symposium, of our conference. Thank you.
Thank you.
conference. We'll now resume the conference, and for this afternoon session, the topic will be Philippine and Japanese law and procedure on inheritance. I wish to invite on stage our moderators, right? Moderators for this afternoon. Is it two? Two of you. Our moderators for this afternoon, a graduate of QDai. He did his LLM in Kyushu University, a faculty member of the UP College of Law, and a partner in Cruz Marcelo and Tenefrancia Law Offices, Attorney Jerome Canlas.
Good afternoon and thank you, Prof. Raj. So, good afternoon. I am Jerome Canlas, as said by Prof. Raj. I am also a lecturer here at the UP College of Law, and I will be your moderator for the second panel on Philippine and Japanese law and procedure on inheritance. As we will see from the presentations by our speakers, the Philippines and Japan are both civil law countries and share a common goal of ensuring fair and equitable distribution of assets among heirs. However, each country is governed by distinct legal frameworks with respect to inheritance as influenced by their cultural values and legal traditions. So more on this will be discussed by our panelists, first of whom will be Attorney Marie Cecil Roque Quintos. She is a senior partner at Poblador Bautista and Reyes Law Offices, whose expertise includes estate planning and inheritance law. She is likewise a senior lecturer at the UP College of Law teaching succession law. Ladies and gentlemen, our speaker on Philippine law, Attorney Marie Cecil Roque Quintos.
Good afternoon, everyone. I'd like to say hello to my colleagues in the profession and in the academe, both from the Philippines and from Japan. So my name is Cecil Quintos, and as mentioned by earlier, I practice estate planning and settlement. I've been practicing for almost 30 years, and I have been teaching succession in the UP College of Law, also in the Lyceum College of Law for maybe around 15 years. When life in the Philippines began to normalize after the pandemic, I noticed a sudden influx of requests from our clients for help to draft their wills. And they also have a lot of requests for opinions on various questions relating to inheritance issues. Maybe those of you here from the same practice may have experienced the same thing. Clearly, one of the effects of the pandemic was it made people realize or come face to face with their mortality. And as a result of that, they wanted to get their affairs in order. I just want to tell the story of a client who, right after she was discharged from the hospital, she was in the hospital for 3 weeks for a serious COVID case. She told me that I was the first person she called after she was discharged because she wanted to make her will immediately. So I'm not sure if it's a good thing, no, that people only think of me when they have a sudden brush with death. Okay. My task today is to give you a preview of the Philippine law and procedure on inheritance. There are three kinds of succession in the Philippines. We recognize testamentary succession, wherein the decedent dies with a will, and we also have legal. We also have legal or intestate succession, where the decedent dies without a will, or he left a will and it was not given effect for any reason. And we also have mixed succession. Okay, so this is, by the name, it's a combination of both. So this may result if the testator died with a will, okay, but the will did not cover the entire estate. And the part of the estate that's not covered by the will then pass to the heirs by the rules of intestacy. Okay, the kind of succession of a person will have an effect on, one, the identity of his heirs, two, the sharing of the heirs in his estate, and three, to a certain extent, the manner of settling his estate. We are a system of partial reservation. The law requires a person to reserve a certain portion of his estate for his compulsory heirs. And this portion is called, we call it the legitim. As to the procedure for the settlement of a decedent's estate, we have two kinds, the extrajudicial and the judicial. We will go into that later. Okay. So, under Article 16 of our Civil Code, intestate and testamentary successions, both with respect to the order of succession and to the amount of successional rights and to the intrinsic validity of testamentary provisions, shall be regulated by the national law of the person whose succession is under consideration, whatever may be the nature of the property and regardless of the country wherein the property may be found. In other words, our inheritance laws apply to decedents who are Philippine nationals. So I will be going through certain key terms na lang and concepts on succession, just to give you a bird's eye view of our law. Okay? So the first concept is the vesting of succession rights. The rights of the succession are transmitted from the moment of the death of the decedent. This means that the rights of the heirs of the decedent vest only upon his death, okay, regardless of when they get to actually have physical possession of the properties. This is also why our law prohibits contracts on future inheritance. The law at the time of the death will govern the inheritance rights of the heirs. For example, we have a case wherein the decedent died during the effectivity of the Civil Code, so prior to 1955. Under the old Civil Code, illegitimate children were not entitled to a legitim. So when the new Civil Code was passed, the mother of the children tried to, the new Civil Code now gave illegitimate children an entitlement to a legitim. So the mother tried to invoke the provisions of the new Civil Code, but the court, in that case, applied the rule that the law at the time of the death of the decedent should govern. Okay. So if the decedent left a will, the will takes effect from the moment of his death, subject to its probate. Okay, so our next term is inheritance. By definition, inheritance includes the property rights and obligations of a person which are not extinguished by his death. As to property, this would be all of the real and personal property that are owned by the decedent at the time of his death. Rights which are patrimonial or relating to property are generally transmissible. An example of a patrimonial right would be the right to file an action for quieting of title, or the right to annul or file an action to annul the foreclosure of a real estate mortgage. Money debts are chargeable against the properties of the estate. So if the assets of the estate are not sufficient to cover the debts of the decedent, the heirs cannot be made to pay the uncollectible balance. Other obligations survive, like leases, contracts to buy property, guarantees, and suretyships. Examples of rights and obligations which are extinguished by death include those arising from marriage, or the action to annul a marriage, the obligation to give legal support, the right to receive support. Our next term is a will. Okay. Philippine law requires that a will be in writing and in the language known to the testator. We recognize two kinds of wills, the notarial will and the holographic will. A notarial or attested will, as the name suggests, must be attested by 3 credible witnesses and notarized before a notary public. A holographic will, on the other hand, is one that is entirely written, dated, and signed in the handwriting of the testator. Our laws do not allow joint wills. So joint wills are prohibited in the Philippines. A joint will shall not be valid even if the Filipino executes it in a foreign country which allows joint wills. Okay. Wills take effect after the death of the testator, but they have to be probated before the heirs can take or can assert rights pursuant to the will. Okay, so we recognize an ante-mortem probate, wherein it is the testator who will file for the probate during his lifetime. And we also have the post-mortem probate, which is the more usual case. The heirs of the testator will be the ones to file for the probate of the will. Okay. So the purpose of the probate is basically to establish the authenticity of the will, the formal validity, and the testamentary capacity of the testator during the execution of the will. Okay. Our civil code provisions on inheritance law have not been amended since the code was passed in 1955. So wills that are recorded on video, for example, are not contemplated in our civil code. So so our modern technology today, they may not be supported, or wills executed using modern technology may not be probated, but there's still no jurisprudence on this. But what about a holographic will written, for example, on your iPad using the Apple Pencil? So it will be handwritten, okay, in your handwriting. You can sign it, you can date it. So would that not pass as a holographic will under the Civil Code? I don't think there's a case yet on this matter, but if I could hazard a guess, it should be allowed to be probated, provided that, you know, the petitioner can establish the authenticity of the will. Okay. So what laws govern the formalities of wills of foreigners? Article 816 says that the will of an alien who is abroad produces effect in the Philippines if made with the formalities prescribed by the law of his domicile or of his national law, or in accordance with the Civil Code. So if you give an example, Mikasa, okay, a Japanese national residing in Singapore, she can make her will following the formalities of the law of Japan, her national law, or Singapore, the law of her domicile, or the Philippine law. Okay. Our Article 817 also provides that the will made in the Philippines by a foreigner, which is executed in accordance with his national law, and which might be proved and allowed by the law of his own country, shall have the same effect as if executed under Philippine laws. So if Mikasa makes her will in the Philippines following the formalities of Japanese law, okay, this would be valid in the Philippines, provided that she can establish that the will be approved in Japan. Okay, so this brings us to our first, maybe not really fun, but interesting fact. Para may break tayo. Okay, so interesting fact number 1, it is legal for a testator in the Philippines to impose a condition on his spouse not to contract a second marriage. The same goes for the testator's parents or children. Okay. So, but take note, this is an exception. The general rule actually is it is prohibited to impose as a condition that an heir contract a first marriage. And this is the exception. Okay, so our next term is legitim. Legitim is that part of the testator's property which he cannot dispose of because the law has reserved it for certain heirs who are called the compulsory heirs. If a person decides to make a will, there is a restriction imposed by law on him in disposing his estate. He may only dispose that part that is left after the legitim of his compulsory heirs are all provided for. So if the dispositions in his will infringe upon the legitim of the compulsory heirs, the latter will have the right to claim for completion. This may entail the reduction of the dispositions of the testator to other persons or the outright setting aside of those dispositions. Okay, so the testator cannot prohibit his compulsory heirs from getting their legitims. Okay. The only instance that the law allows a testator to deprive his compulsory heirs of their legitim would be by disinheritance. Okay. For disinheritance to be valid, it must be for a cause provided by the Civil Code, and the cause must be specified in a will. For example, the grounds for disinheriting children and descendants are as follows. It's there on the slide. So number 1, the child has been found guilty of an attempt against the life of the testator, his spouse, descendants, or ascendants. Number 2, the child has accused the testator of a crime for which the law prescribes imprisonment for 6 years or more, if the accusation has been found groundless. Number 3, the child is convicted of adultery or concubinage with the spouse of the testator. Number 4, when the child, by fraud, violence, intimidation, or undue influence, causes the testator to make a will or change one that he has already made. Number 5, a refusal without justifiable cause to support the parent. Number 6, maltreatment of the testator by word or deed. Number 7, when the child leads a dishonorable or disgraceful life. Number 8, conviction of a crime which carries with it the penalty of civil interdiction. So the grounds for disinheriting a spouse, if you will look at the list, they're more or less similar, no? So if the cause is not stated in the will, or if the cause given by the testator is not those provided in the Civil Code, or turns out to be false when challenged, then the disinheritance becomes ineffective, which would then result in the annulment of the institution of heirs in the will, insofar as it may prejudice the person disinherited. So this means that the heir who was ineffectively disinherited must be given his legitim. Okay, so our next term is heirs. Okay, so an heir is called to the succession either by the provision of a will or by operation of law. So we have three types of heirs. We have the compulsory heirs, we have the voluntary or testamentary heirs, and we have the legal or intestate heirs. As I mentioned earlier, the compulsory heirs are the ones who are entitled to receive a legitim out of the testator's estate. And this would be the children, the legitimate children and descendants, and also referred to, we have that. Okay, also referred to as the primary compulsory heirs, because if there are legitimate children and descendants, they will exclude the parents and ascendants, which is our second classification. So the parents and ascendants are referred to as secondary compulsory heirs. They only get a legitim in the absence of children and descendants. And then we have the widow or widower as a concurring heir, and the illegitimate children, also a concurring heir. So this means that whether there are children or parents, the widow or the surviving spouse and the illegitimate children will also get a legitim. Okay. So voluntary heirs are testamentary heirs. They are persons outside of the family who are instituted by the testator. Okay. And then we have the intestate or legal heirs. So if a person dies intestate, the civil code assumes that he intended his estate to devolve to his family and close relatives. Okay. So the intestate heirs consist of the legitimate and illegitimate relatives of the deceased, the surviving spouse, and the state. Relatives include parents and other ascendants. And also collateral relatives up to the 5th degree of consanguinity. If the decedent is an illegitimate child, however, only collateral relatives who are brothers and sisters and nephews and nieces will be entitled to a share in the estate. In the absence of all of these relatives, the estate will be escheated to the state. Okay. There are rules that we have in intestacy to determine who among the intestate heirs will inherit. So the first rule is the rule on preference of lines. The descending line will be preferred, so it will exclude the ascending and collateral lines. The ascending line will also exclude the collateral line. And then we have the rule of proximity. So the relatives nearest in degree will exclude those who are more remote. So if there are children and grandchildren, the children will exclude the grandchildren. And then there's the rule of equality, meaning relatives in the same degree will inherit equally, subject to certain exceptions. So, for example, the only intestate heirs are brothers and sisters, but some brothers are some are half brothers. Okay, so the law says that the share of the siblings of the half-blood will be half of that of the full-blood relatives. There's also a preference in the civil code for legitimate over illegitimate relations. So in terms of sharing, legitimate children are entitled to double the share of an illegitimate child. And we have also this article, which is commonly referred to as the Iron Curtain Rule. It's Article 992 of the Civil Code, which says that an illegitimate child has no right to inherit from his relatives, from the relatives of his father or mother, and vice versa. So meaning, if A, for example, is or has an illegitimate child X, okay, and A is the son of B, okay. If A predeceases B, no, X, being an illegitimate child, is not allowed to represent A in the inheritance from B. Okay, so this is what's referred to as the Iron Curtain Rule. Okay, but in a recent case, no, it was a decision based issued only in December of 2021. The Supreme Court, in the case of Aquino versus Aquino, rendered this decision, which kind of rocked the boat vis-a-vis the Iron Curtain Rule. So in that decision, the court says that in the same situation, no, X has a right of representation. So there were, first of all, that case is peculiar in the sense that it never used the terms legitimate child and illegitimate child. It used the words non-marital child and non-marital child. Okay, so, and it gave, unfortunately, Professor Beth is no longer here, but she was, she contributed expertise, no, on the definition of relatives in that case. So that case essentially said that an illegitimate child can represent her parent in the inheritance from the grandparent. So, all right. All right, so let's go to sharing in testamentary succession. So I mentioned earlier that the kind of succession will have an impact on the sharing of the heirs in the estate. So in a case of testamentary succession, the legitim of the legitimate children would consist of half of the estate, while that of the surviving spouse would be the same as one legitimate child, if there are more than one legitimate child. So in our example, we have 3 legitimate children. I mean, the testator is survived by 3 legitimate children, his parents, and his surviving spouse. So the parents, being secondary compulsory heirs, they're excluded by the legitimate children and would therefore not be entitled to a legitim. So the estate would now be, or I mean the only heirs who would be entitled to a legitim in this case would be the children and the spouse. And their sharing would look like this. Okay, so 1/2 of the estate will be divided equally among the 3 legitimate children, and the spouse gets the same share as one legitimate child. So the balance, which is in purple in this chart, that's the free portion. So that is what the testator can give to whoever he wants. Okay? So let's change the problem a little. The ones who survive the testator are 2 legitimate children, 1 illegitimate child, the parents, and the surviving spouse. So parents are still excluded, okay? And the share of the illegitimate child is half of that of one legitimate child. So the two legitimate children will take 1/2 of the estate, so each will get 1/4, and then the surviving spouse also gets 1/4, and the illegitimate child gets 1/2 of 1/4, or 1/8. So it will look like that. So the free portion now would be only 1/8 of the estate. Okay. So how will the sharing be in intestate succession? Okay. So in intestate succession, the entire estate will now be distributed to the heirs. So in the same scenario, the first scenario earlier, but now intestate, still the parents will be excluded, okay, and the estate will be divided equally now among the children and the spouse. Okay, so that is how it will look like. Because the rule is the spouse gets the same share as one legitimate child. So in the second problem, in intestate succession, 2 legitimate children, 1 illegitimate child, parents and surviving spouse, parents still excluded. The illegitimate child gets half the share of 1 legitimate child. So the ratio now will be 2:1. So it will look like this. Okay. So based on a 2021 report of the Philippine Statistics Authority on marriages between Filipinos and foreigners, the highest number of foreign marriages among Filipino women were with 1, Americans, 26.8%, followed by Japanese, 10.6%, British, 6.6%, Koreans, 6.3%, and Canadians, 5.7%. So let's discuss a couple of situations that Attorney Raj asked me to discuss. Okay, so in this first situation, it will involve a Japanese decedent. Okay, so a Japanese man married a Filipina, okay, had a child with her, acquired properties in Japan and the Philippines, obtained a divorce in Japan, married another Filipina, had another child with a second wife, and also acquired properties during the second marriage in the Philippines and in Japan. So the question is, who will be the heirs of the decedent and what are their shares in the estate? Okay. So the answer to these questions will have to be answered under Japanese law, which is the national law of the decedent. Okay. So in the second situation, okay, so the second situation involves a Filipina decedent this time. So a Filipina married a Japanese, had a child with him, acquired properties in Japan and the Philippines, obtained a divorce in Japan, married another Japanese man, okay, and had a child with a second husband, acquired more properties in Japan and the Philippines, and then she died. Who are the heirs of the decedent in this case? And what are their shares in the estate? Okay, so because the decedent is Filipino, Philippine laws apply. Okay, so her intestate heirs would then be her second husband and her 2 children from the 2 marriages. Okay, so they would then be entitled to, they will then divide the estate equally among the 3 of them. Okay. So, presuming the second marriage is governed by our family code and was under the regime of absolute community of property, Her estate upon her death would consist of her share in the, her 1/2 share in the community property. And that community property consists of her share from the first marriage and her share in the properties acquired with the husband in the Philippines and Japan. Okay, so this brings us to our second interesting fact. Okay. A and B are married. They're childless. A has a brother and sister. A dies intestate. Okay, who will now be entitled to the estate of A? Or the otherwise stated, it's usually common to think that in a situation like this, the wife will be entitled to the entire estate. But under Article 1001 of our Civil Code, B would only be entitled to 1/2 of the estate, and she has to share the other half with the siblings of her husband. Okay, so we now go to the manner of settlement of estates. Okay, intestate succession is more common in the Philippines, and estates are most often than not extrajudicially settled, okay, with the heirs executing a deed of extrajudicial settlement. So this is basically an agreement that must be signed by all of the heirs of the decedent, and they agree among themselves on how to divide the estate. The heirs would then need to pay to the Bureau of Internal Revenue the estate tax due on the estate of their decedent. And our current estate tax rate is 6% of the net estate after all the allowable deductions. Okay, so after payment of taxes, the BIR will issue the heirs with this document. It's called a certificate authorizing registration. And this is what the heirs will need to bring to the various registries of deeds where the properties of their parent are located, so that the title to those properties will be transferred to their names as provided in the deed of extrajudicial settlement. So if the decedent left shares of stock, the CAR will also be the document that they need to submit to the company secretary of the companies, so that the stock certificates will be reissued to the names of the heirs. Okay. If there's a disagreement among the heirs, they will have to file an action for partition or for judicial settlement of the estate. Okay. So in the latter, in judicial settlement, the applicable rules are Rules 73 to 90 of our Rules of Court. So it's very long, but let me just summarize what they say. So basically, the heirs, or it can be the executor or the administrator, will have to file the petition in the regional trial court where the decedent resided at the time of the death. If he was residing abroad, it can be filed in any RTC or regional trial court where he has properties. Okay, then the first, after filing the petition, the court, after notice and hearing, notice to all of the heirs, there's publication, the court will then appoint the executor or issue letters of administration to the executor or administrator. The executor or administrator will then have to file an inventory of the properties of the estate, okay, as well as the list of claims against the estate. During the process, certain properties, upon petition of the executor, may be allowed to be sold to answer for the claims of the creditors, or for legacies in the will, or to pay for the estate tax. Okay. So after all the claims are settled, the residue will be delivered to the heirs of the decedent by order of the court. Okay, so with this, I end my lecture with what may already be a trite quote from Benjamin Franklin, that in this world nothing is certain except death and taxes. Thank you.
So thank you for the comprehensive and interesting discussion, Attorney Roque Quintos. So now we know that under Philippine law, a greater emphasis is placed on the rights of heirs, and testators do not have complete freedom to fully dispose of their assets. In contrast, Japan, and as will be discussed by our succeeding panelists, they grant more autonomy to the individual in determining the distribution of their assets. So now I am turning the floor to Masao-san, who will introduce our next speakers.
Hi, good afternoon, everyone, again. Our second speaker for this afternoon has extensive experiences in the field and also has close tie with UP and the Philippines. She studied community development at UP Diliman as an exchange student back in 1998 and became interested in JFC, or Japanese Filipino children issues. 20 years later, in 2017, as Professor Palacio mentioned earlier, she was sent by the Japan Federation of Bar Association to conduct a feasibility study for the Philippines project and stay in the UP Diliman campus once again for a year. She currently specializes in corporate law as an in-house lawyer, but still has passion to be involved in the family law issues between Japan and the Philippines for the rest of her life. Today, she will give us a presentation on Japanese law and procedure on inheritance, focusing on the law proper. Welcome back to the Philippines, and please join me in welcoming Attorney Keiko Sugawa.
Thank you, Attorney Masao. Hello, everyone. This is my second time speaking here in UP-BGC since 2017. Tuan tua akong bumalik. And I'm very happy to be back. Thank you. And in my part, I will briefly explain to help you understand the Japanese inheritance before the case study in the next presentation by Kaori. Okay, first, let's see which country's civil law applies to international inheritance cases. And Japanese rules for application of law says inheritance is governed by the national law of the decedent. So it's the same as the Philippine civil law. If the decedent is Japanese, Japanese civil code will apply. And if the decedent is Filipinos, we need to refer to civil code of the Philippines. And in Japan, there are two kinds of inheritance, testate and intestate. But in Japan, not many people make valid wills. So most inheritance cases are resolved according to the civil code. So I will briefly introduce the general inheritance rules stipulated in the Japanese civil code. Okay, who are the legal heirs? And this is the order of the legal heir. If there is a surviving spouse, he or she is always an heir. And other than spouse, these persons become heirs in accordance with this order. And the decedent has children, then the children are heirs of the first rank. And if there are children but no spouse, the entire succession goes to children. And if the decedent has no children, the decedent's lineal ascendant are the heirs of the second rank. Parents shall have higher priority than grandparents within the second rank. And if there is no parent and no grandparents, the siblings are the heirs as the third rank. And heirs can choose to accept or renounce the inheritance, so that the heirs who renounced are considered to have never been heirs from the beginning. And partners in common law relationships are not included as heirs. And next slide is about the legal shares of each group of heirs. If the decedent has a spouse and children, the respective shares of inheritance are as stated in number 1. The spouse inherits half, and the children inherits the other half. Sorry, this one. And in this case, other group of heirs inherit nothing. And number 2, if the decedent has a spouse but no children, the spouse inherits 2/3 and the lineal ascendants inherit 1/3. And if all the lineal ascendants have already passed away, the spouse inherits 3/4 and siblings inherit 1/4. If there is more than one child, parent or siblings, this portion will be divided equally. For example, if there are 2 children, the children's share of the inheritance will be 1/4 each. And the legally reserved portion is half of the legal inheritance share of the previous slide. And siblings do not have a legally reserved portion, so they cannot claim even though more than half of their inheritance is infringed, because siblings is the most distantly related to the decedent. Sorry, I used animation on this slide, but it's not showing. Okay, so I will move on next one. Yes. I mentioned earlier that if there are more than one child, the share is equally divided among the children. But the share of illegitimate children used to be half of legitimate children. This Article 900, paragraph 4, this is a provision before the amendment. Now the sentence in red have been deleted, and illegitimate children inherits in the same portion as a legitimate child. The sentence was deleted because 10 years ago, the Supreme Court in Japan declared the provision is unconstitutional and invalid. The Supreme Court stated, it is not permissible to discriminate against a child on the basis of the fact that the parents were not married under the legal marriage system, a matter that the child has no choice in and no ability to change. In this case, the plaintiffs were JFCs who were born to Filipino women and Japanese men. So yes, JFC, they contributed to the fairness of Japanese law. But of course, illegitimate children must be recognized by a decedent in order to become heirs. And there are two ways to voluntarily recognize an illegitimate child. One is notification. A parent submit notification to the city hall. Or another is recognition by will. This might cause a trouble when the inheritance happens, but maybe a parent don't want to his or her spouse to know that there is an illegitimate child, or the parents don't want to pay child support, may take this means. And if the parent won't recognize voluntarily, the child will, the illegitimate child may file an action for compulsory recognition. And when the child is recognized, the child will be listed in the family register. The family register will certify that the child is an heir. But in the case of JFC, it is possible that the Japanese father is elderly and has already passed away by the time the child tried to request recognition. But please note, don't give up. And please check the date of the death in the family register, because an action for compulsory recognition can be filed within 3 years from the date of the parent's death. Okay, with regard to the effect of inheritance, according to Article 896, upon the death of the decedent, both debts and claims are transferred to the heirs automatically without court involvement. And there are two kinds of properties: divisible properties and indivisible properties. And in case of divisible claims and divisible debts will be divided as a matter of law and will be succeeded to by each co-heir in portion to his or her heirs. These properties are not subject to the division of property. An indivisible claim, such as real estate, cash, stocks, and bank deposit, so it will be jointly owned by the heirs until the estate is divided among the heirs. I will explain later the procedure of the division of inherited property. And in regard to bank deposit, there was a dispute whether the bank deposit is divisible or indivisible. But the bank, anyway, did not allow refunds prior to the division of the estate. And the Supreme Court has clarified that they are not divisible claim in 2016. And of course, purely personal rights, like right to claim support or divorce or recognition, will not be inherited. This is because they cannot be converted into money. And the procedure for division of property, Article 907, and paragraph 2 says, if agreement is not or cannot be settled between joint heirs regarding division of inherited property, each of the joint heirs may make an application to the family court for division of the inherited property. So, but that means division by mutual agreement is the first option. And if agreement cannot be reached, the heir may apply to the family court for division by mediation or judgment. I mentioned that divisible properties are already divided upon the decedent's death, but in the procedure, we usually discuss all the properties together. And this is the effect of division of property. According to Article 909, division of inherited property shall have retroactive effect from the time of the commencement of inheritance, provided that this shall not prejudice the right of third party. So the division of the estate will take effect retrospectively upon the death of the decedent, but the division may not affect the third party who acquires decedent's property before the division. Therefore, if an heir sold its share in the succeeded land to the third party before the division, and the third party registered such transaction, the third party will have priority due to the public nature of the registration of the real estate. Okay, this is the end of my presentation. And inheritance issues are a future of divorce issues. And inheritance disputes between Japanese and Filipinos are already increasing. And there will be more in the future. So I would be very happy to cooperate with you in the issues of inheritance. Thank you very much. Salamat.
Thank you very much, Attorney Sugawa, for a very informative presentation. So last but not least, we have another speaker from JFBA who is frequently working for Filipino clients as a private practitioner in Japan. She will give us some case studies for Japanese law and procedure on inheritance. She's from Tokyo Public Law Office. Tokyo Public Law Office is established by and with support from the Tokyo Bar Association, one of the local bar associations under JFBA. At her law firm, she belongs to the Foreign Nationals and International Services section. This section is a specialized department to overcome barriers people with foreign roots often face when they need an access to justice in Japan. As a member of the group, she handles legal matters for the Filipino clients on a daily basis. Ladies and gentlemen, please welcome Attorney Kaori Okubo.
Thank you, Mr. Dan. Hello, my name is Kaori Okubo. I'm a member of Tokyo Bar Association and a member of JFBA. So in this conference, we are given two scenarios given to the speakers. Situation one is Japanese decedent, a Japanese man married a Filipino, had a child with her, acquired properties in Japan, and the Philippines obtained a divorce in Japan, married another Filipino, had a child with a second Filipino wife, acquired more properties in Japan and the Philippines, and then died. And the situation two is the opposite way around. So the previous presentation explained how the Philippine laws and Japanese laws of inheritance works. So I would like to explain a little more specifically about these given situations and how the legal consultations will be conducted and procedures will be followed in my presentations. So situation 1, I would like to start with the situation 1. So I would like to elaborate the situation a little bit more in details. So timeline is as follows. Please note that all names and events are fictional. So Mr. Kazuo Yamada, born September 8, 1947, he aged 76, male, and he has a Japanese nationality. February 1975, married to Miss Jessica Garcia Yamada, female Filipina. And in 1980s, a child A was born to Jessica, has both Filipino and Japanese citizenship. But unfortunately, in 1987, Kazuo divorced from Jessica. It was divorced by agreement in Japan. And in 1919, Kazuo married again to Marian Louise Yamada, female Filipina, and they moved to Philippines in the same month. And in 1991, child B was born to Marian and Kazuo, and child B has both Filipino and Japanese citizenship. In 2000, child C born out of wedlock to a Filipina woman, and name is unidentified, and she has Filipino nationality only, but not registered as Japanese national, obtained Japanese nationality yet. And September 2023, Kazuo Yamada died, and his inheritance begins. Okay. Let's say like your client is A, and A's story continues like this. So A was 7 years old when Kazuo and Jessica divorced, and his mother Jessica took custody over him. Thereafter, Kazuo and A interacted with each other. However, after Kazuo remarried Marian in and half a brother B was born, Kazuo and they ceased to communicate. However, A continued to communicate with Kazuo's grandparents. The grandparents told him that Kazuo had a second wife, and they have another child, B, was born to Kazuo and Marian. Then both grandparents passed away. The grandma in 2013 and grandpa in 2014. A has been living at the grandparents' house after the death of his grandparents. A has had a permission from his grandparents to use the said house. The house and the land were registered in the grandfather's name. So in November 2023, In November, so 2 months after Kazuo died, A found out that Kazuo passed away. A heard from Kazuo's friend that Kazuo had died in the Philippines. So according to the friend, Kazuo owned 3 restaurants and several apartments in the Philippines and was having very wealthy life. So A conducted research on Kazuo's estate in Japan, but Kazuo had no real estate or savings in Japan. A wants to inherit the property in Kazuo's name in the Philippines, and he also wants to transfer the registered title of the house from his grandfather's name to himself. So I would explain the characters in this situation. So Kazuo was born from grandpa and grandma, and married to Jessica and had an A. And after that, divorced in Japan by agreement. After that, he remarried to Marian and had a B. And somewhere else, after that, he had a relationship with another woman and child C was born. So it concerns who are the heirs, and am I entitled to inherit my father's property in the Philippines? And also the third one is I want to transfer the registered title of the land and buildings of my grandfathers. So first question is to consider which country's law will be applied to this case. And as Keiko explained, I'm sorry, it will be the decedent law, nationality of law. So this case, Kazuo is a Japanese citizenship, so Japanese law will apply to this inheritance. So who are the heirs? As Keiko explained, if the decedent has a wife and the children, the wife and the children are the heirs. In practice, first we obtain the family registry of the decedent in order to certify that client is one of the heirs. The family registry is called koseki, and it looks like this on the right side. And in koseki, there are information the person's permanent domicile, name, personal status, such as date of birth, date of marriage, date of divorce, and date of death, etc. In the family registry, the legally recognized child is also listed as a child. So the legally recognized child is also listed. Both legitimate child and illegitimate child will be listed in the same family registry. So remember, Kazuo had a child C. The question becomes, is she the heir of Kazuo? So it depends if the Kazuo has affiliated C as a legal child or not. I'm sorry, my slide animation is not working. So if Kazuo has affiliated C as his child, then he is registered in the family registry. That means he has enough proof that he is a child of Kazuo, which means he is the heir of Kazuo. And his share will be the same as other children of Kazuo. So in this case, Marian, one half goes to Marian and 1/6 goes to A, B, and C. And if Kazuo did not affiliate C as his child, then he is not in the family registry, which means that he is not yet legally entitled to Kazuo's inheritance. So yet means that he can file the claim of post-mortem recognition affiliation. She must, as Keiko explained, she must file this petition within 3 years from the time of his father's death. So in this case, she hasn't filed the affiliation claim, so she will get none, and 1/4 will go to A and B. Yes, this is already explained, so I will skip this part. So in this case, situation 1, another inheritance has occurred. This is an inheritance in which the grandfather is the decedent. In Japan, many people die without making a will. In addition, if a long period of time has passed without being discussed regarding how to split the property, during those times, another inheritance might happen like this. And this is not uncommon for the inheritance to have occurred several times. And this is the grandfather's, the child A is living in grandfather's house, and the house is registered under grandfather's name. So we have to talk about the inheritance of the grandfather. So who are the heirs of grandfather? Since the grandmother had passed away before the grandfather passed away, Kazuo was only the sole heir of the grandfather. So Kazuo's share was 100%. Then Kazuo passed away, and Jessica and Kazuo divorced by agreement before Kazuo passed away. And in Japan, as been presented and discussed before, the divorce by agreement is effective. So Jessica is not entitled to Kazuo's inheritance. And Marian is the wife of Kazuo. She will inherit 1/2 of the estate. And as I explained to you before, there's a difference whether she was affiliated by Kazuo or not. So the share will be either A, B, and C gets 1/6, or A and B gets 1/4, and she gets 0. So in this case, only A resides and uses the house under the grandfather's name. However, this estate, the land and the building of the grandfather, is actually co-owned by the heirs of grandfathers. So if A wants to transfer the registration of the real estate from his grandfather's name to A, he cannot take the procedure by himself, by alone. He needs a cooperation and agreement of the other heirs. So this is going to be very difficult, since Marian and B is living in the Philippines, and probably depends on whether or not she is affiliated or not, but probably A cannot contact the C. So it is very difficult to obtain an agreement from all the heirs. So the scope of heirs and the portion of inheritance are now determined. So next issue is the extent of estate, the extent of inheritance. So what we do is a research. First of all, we look for the property and assets. So for the land and buildings, to find out who owns the real estate, we first obtain the real estate registry called Fudosan Tokibo, Tohon, or Tokijoho. A real estate registration is a document like the sample on the right. It shows who owns the land or who owns the specific buildings. Also, there is a document that lists all taxable land and housing by the owner called Nayosecho. It means name book. When inheritance occurs, the Nayosecho can be checked to identify all real estate owned by the decedent. Continues with how to investigate the assets. Then we'd like to know how much money Kazuo had in his deposit and savings. So there's no system that lists all the savings or checking account of the decedent. So it is required to make an official inquiry to each bank individually. Also, credit information is important. Records of previous loans and contracts and transactions are kept in the Credit Information Agency. If there are any outstanding debts, they are also recorded in the credit information. So the heir would have an idea how much debts or obligation the decedent have. And please note that life insurance is considered as, in principle, life insurance a property unique to the beneficiary. Therefore, it is not subject to the division of the estate in which the decedent's property is divided among the heirs. There should be an exception to it. Sometimes the heirs can claim some portion of the life insurance acceptance money. However, in principle, it is excluded from the division of estate. Okay. So in the absence of will, the heir have to discuss how to divide the estate. This is called 이산분割協議. So civil code stipulates the share. However, if all the heirs agree, they can split the inheritance differently from the civil code. So the problem arises when the heirs are unable to reach an agreement. In such cases, the discussion will be held through the court procedures, as Keiko explained. And jurisdiction of the decedent's is the decedent's last address. The court within jurisdiction over the place where the decedent passed away has a jurisdiction over his or her inheritance. So in this case scenario, Kazuo had no property in Japan, but was likely to have some property and assets in the Philippines. Since the Japanese law applies to this case, and it is also applies to the asset in the Philippines, A is Kazuo's heir. So what would happen if the division of the estate had been completed in the Philippines is that in Japan, as Keiko explained, the Civil Code Article 1028 stipulates the entitlement and amount of legally reserved portion. So from the point of view of A, first we check to see if Kazuo had left any will or not. Then according to the will, if the property in the Philippines are divided, then A will claim the legally reserved portion of his share. So it will be 1/2 times 1/4 or 1/6. So it's gonna be 1/8 or 1 out of 16. If the division is made by agreement, then obviously A is excluded in this process. So A will have to claim that agreement is invalid, and they have to redo the division agreement again. So there was two case scenarios, and situation 2 was a Filipino married to a Japanese man, had a child with him, acquired properties in Japan and the Philippines, obtained a divorce in Japan, married another Japanese man, Japan and the Philippines, and then died. So the same problem, same issues will arise. However, this procedure is governed by the Philippines laws of Philippines. So applicable law is the laws of the Philippines, Philippine Civil Code. And if the person files this case in Japan, then Japanese court will take this case and apply the Philippine laws for the inheritance if they have jurisdiction over this case, which means that Filipino woman was, her last address was in Japan, then Japanese court will handle this case and they will look for the laws of Philippines. Okay. Okay, this is the end of my presentation. Thank you.
Thank you, Attorney Kaori. And now we'll be opening the floor to questions. So, Masao-san will help us with the questions. We can take questions from the floor. We also might have questions online, and Attorney Masao can read the questions. Are there any questions from the floor? You can also indicate which particular speaker you want to answer the question. Maybe we can proceed with the online questions. Masao-san?
Okay. We have one question from online participant, and it's a bit interesting. The question is, what if the decedent has a dual citizenship? Let's say US and the Philippines. So which law applies to his or her inheritance?
Maybe we can have Attorney Roque Quintos answer that question.
Okay, I have an answer, but I request Attorney Raj to correct me if I'm wrong, because this is actually a PRIL question, private international law. So my answer to that question would be, for purposes of inheritance, he would be considered Filipino. So since he's Filipino and US, so he will be considered Filipino for purposes of inheritance law.
It would be the same in Japan because he or she has a Japanese and another country's nationality, then Japanese law will apply.
Thank you, Attorney Roque Quintos and Attorney Kaori. Do we have more questions? So we have no more. The presentations were very clear. That's why we have no questions. So I'd like to call on Prof. Raj to have his final speech.
Okay, thank you very much to the speakers, Attorney Marie Cecil Roque Quintos, Attorney Keiko Sugawa, Attorney Kaori Okubu, and also our moderators, Attorney Jerome Canlas and Attorney Masao Dan. May I now invite the head of the JFPA Center for Promotion of International Legal Services, Attorney Yoshiaki Muto, for his closing remarks.
Thank you very much. I am Yoshiaki Muto, Chair of JFBA's Center for Promotion of International Legal Services. Before finishing the very highly productive and fulfilled day, let me offer a few remarks before the end. First, I have to thank very much all of you who participated in organizing this event, especially our collaborative partners, Integrated Bar of Philippines and the University of Philippines, who offered tremendous friendship, cooperation, and collaboration to this event happens, and assist members of JFBA in Japan. Hello, everybody, for fulfilling the very much latest information about the family and inheritance law of the Philippines, and also for your members in Philippines for about the Japanese legal issues about the family, divorce, and inheritance. My special thanks personally to extend it to Attorney Antonio Pido, Chair of the National President of IBP, and of course Assistant Professor Andre Precious, of your tremendous contribution, preparation, planning for over a number of times and several months, years, even friendship with our colleagues. And Justice Angeline Quimposare for a fantastic keynote speech and very important remarks about the Philippine court precedent and the jurisprudence. Professor Pangarapan, for your also friendship and supporting our program, especially Mr. Obata being here, and all our speakers on stage for presenting your knowledge, insights with us. And also, I have to say thank you very much for supporting members of this event, staff, organizers, and also our sponsoring organizations, NGOs, and professional associations to supporting our initiative in the last couple of years, long years, and also today, so make this happen. Most importantly, I have to note that there are so many participants in audience in this hall and also online through video who are listening to our presentation and participating by raising very important, interesting questions and bringing more answers from our speakers. Those are practitioners and attorneys who are really doing the legal work for supporting people from Japan and Philippines on a challenging situation of the cross-border marriage, divorce, inheritance, those family issues. Families are closely tied unit, and actually Japan and the Philippines are really closely tied through those families, and how to protect, how to support those people making a friendship and a family tie between two countries is a real key to facilitate the real friendship as a nation between the two countries. In that sense, I really thank all of those who participate and are listening to today's session through physically and through video. In the future, I personally, and also as an organization, JFPA, would like to continue on this fantastic tradition of the cross-border collaboration between Japan and the Philippines over family law, inheritance law, and any legal issues which encounter our people and our companies and our businesses to facilitate the relationship and facilitate more friendship. And on that, I really want to continue on this good tradition of the joint seminar conference for every year, if possible. And we also want to invite everybody to participate in the next session, hopefully next year, hopefully in Tokyo, to host you as your hospitality, as return to your hospitality and friendship. We are very much waiting for that opportunity. There are a few very important remarks during today's session. I especially noted there is a new law legislation pending in the parliament in the Philippines, which may change the landscape. We really want to learn about that, so we will be closely watching through Obata-san and the professor, but also we want to know the more details, if possible, as a next session next year in Tokyo. And also there are many new precedents and issues are emerging in Japan too, so we're gonna follow up all those issues through our members, and we want to really give a feedback about such a Japanese development to you, to more up-to-date and more closely connected, and in the end, we really want to help those people bridging the two countries in the end. Thank you very much.
Oh, this is great. Thank you. Would you like a photo with the panel?
Can we invite the panel members to go on stage or near the stage for a photo shoot? Yeah, please. Please, yes, please. The second panel. Attorney Cody, please. Yeah. The panel first and then with the moderator. Basta we can join them after. Sila muna. Sila muna. I will join. Photo myself. Prof. Reg.
May I invite the National Executive Director of the Integrated Bar of the Philippines, together with the delegation from Japan Federation of Bar Associations. The IBP has some tokens which will be handed to the JFBA delegation by the Chief Operating Officer of the IBP. Sige, sige, assist natin. Sige, you just come here, we'll carry it for you. Sige, assist na natin. Siguro, sabay-sabay na lang, ano? One by one? How do you want it? Maybe, yeah. Okay, picture first. Picture.